Lordship, I would like to mention item number 6. Matter may be taken up next week, Lordship.
After
Next week, Lordship.
you've informed the other side,
Yes,
consent of the other side, Mr.
I'm for the petitioner.
Your name?
For S. Yirang.
S.
S. Yirang.
And then counsel for the appellant, place for adjournment. Release allowed, list after a week.
Next week, Lordship. I give rest.
May I please, your Lordship? Lordships, I beg to mention item number 2. It was a fixed matter, but I'm not so well, my lord.
Item number?
2.
Okay.
My lord, I need some time for preparation, my. My lord, 1 week required for preparation. I'm not at all prepared today because I was under treatment, my lord. Of life.
So, Decca, the impression we have gathered is that even after even after a week, you'll be still in the same position.
No, my lord, because
No, not that we are not saying anything more.
I am under treatment. I'm taking medicine all.
No, it's okay.
Yeah, my lord. I'm a chronic patient of nephrology, my lord.
Oh,
Yes. Of life.
May I please? Your Lordship, here the petitioner is the mother of the detainee. The detainee is postgraduate MA in English from Rajiv Gandhi University and also possesses BA degree. And prior to her detention years, she had been preparing for competitive exam at the Nahalagan. Detainee was one of the aspirants in the postgraduate teacher examination held in Arunachal Pradesh Public Service Commission, which was subsequently found to be compromised in the examination by the commission. The examination held by the Arunachal
Just
Pradesh
a
Public
moment.
Service
Just
Commission
a moment.
came.
We see that the detainee has already been released.
Your Lordship?
The detainee has been released.
Yes, released.
Then what's then how does this matter survive?
Your Lordship, here the detention required because this court maybe they declared a the detention order is illegal and said the order of the detentions and thereafter the compromise thereafter the compensation may be given to the detainee for illegal detention.
National Security. The Arunachal Pradesh Act.
Page 155. Page 155. Yeah. Section 3, page 58, Your Lordship. Power to make order detain a certain person. Merit. The state government or any
No, not,
officer.
not required.
Merit.
Not required. Don't read the act. You are aware of it now. Don't read the provision of the law. Just tell us. Don't read the don't read this.
Okay.
We are aware of it. Just tell us the sections and then you move ahead.
They have to be Your Lordship. When Gamar Pandan lodged in FR alleging leakage of the APCCIC A civil exam paper held on the 27 and 28 August 2022. Apart from the FR, he was also submitted to SP Capital Complex as well as Vigilance, Government of Arunachal Pradesh. Subsequently, Arunachal Pradesh Public Service Commission cancelled the ignition.
Just one query. You see, you are challenging the detention order of 12/5/2023.
Yes, sir.
Correct. After this, perhaps the matter went to the government and the government had this approval.
Yes.
Correct.
Yeah.
Now, this approval order is not under challenge.
No.
And after that, when this challenge was made, the detainee was released. That is in your favor. So therefore, the initial challenge which you are making has been subsequently approved. That approval order of the government is not under challenge.
Your Lordship, the decision is already revoked after filing of the petition. Your Lordship, here Your Lordship is illegal. Your Lordship, detention is illegal. Your Lordship. That is page 10 and para 19. Your Lordship.
You see, if the approval order is illegal,
Yes.
how can the initial order be illegal?
Your Lordship, the detention order is illegal. The detention order may be declared the illegal and set aside before we have made this court.
So it is certain that you are not challenging the approval order.
No, Your Lordship, because the approval order is not challenged. Because after filing these petitions, the government approved the release to the detainees. That is why not challenged. Your Lordship, kindly page 10, Your Lordship, para 19.
You know better, because if without the order of approval being under challenge, how would the present petition survive? The
Your Lordship,
order-
because during the detention, the responding the arresting authority never informed to even the detainees and his close relatives as per the provision of laws. Your Lordship. May I read your statement? On 12 May 2023, police official acting under the respondent 3 came and arrested the detainee Lina Sora, and she has been detained ever since. It is to be stated here that the family member of the detainee, including the petitioner, made assiduous effort in finding out as to why Lina Sora had been detained by the police. However, all that petitioner was told that the detainee had been put under preventive detention under the Arunachal Pradesh Public Unlawful Activity Prevention Act. Since neither the detainee nor his close relative were served a copy of the detaining orders.
You see page 90, paragraph 19, page 10. Paragraph 19, page 10. You're yourself saying that you came to know that the detention, the detainee had been put under preventive detention. It is your own statement.
Yes, sir.
Then you cannot now be permitted to approve and reprove it by saying that no, you were not aware. And paragraph 19 is true to your knowledge. Paragraph 2, page 26. You've got the records about the service of the detention order to the relatives. The detention order must be served either to the detainee or to the close relatives.
So for what I understand is the lawsuit, the present petition lawsuit, it become in process lawsuit.
No, but
So the detention order lawsuit.
no, but once he alleges that the initial detention order was never served,
On that aspect lawsuit. Here it lawsuit see the interim order. The copy was OC concern was directed to serve the copy lawsuit
whether it was done,
because he was under detention lawsuit.
whether it was done.
And here lawsuit, because the extra copy was not served, therefore the state could not take into the OC concern lawsuit.
Okay.
No, here lordship, the as per this impugn order lordship, concerned SP and the OC was directed to serve a copy. Lordship. And so far with the copy, how the copy has been served lordship. In that aspect lordship, I may allow to bring lordship the records how it has been served. Otherwise, lordship, here two concepts. One lordship at the time when this order was passed, lordship, whether the traditional law comes under this very unlawful lordship person or not, lordship. Because subsequent serving and not serving, look. Oh, now what I'm submitting is lordship. Even if the copy is not served, for example, lordship, the initial lordship order itself, it doesn't become illegal lordship, but the further continuation is lordship illegal lordship. What I understand. Therefore, lordship, the legality and illegality of the detention order itself has to lordship examine as per the provisions of law and the lordship prevailing what circumstances. No. So, okay. Here the ground of challenge lawsuit. The ground of challenge is not that lawsuit, the impugn order itself is illegal. But since the subsequent lawsuit action, which should have been taken by the authority, has not been taken lawsuit. Therefore, the initial order is lawsuit illegal. These two aspect lawsuit has to be lawsuit.
Your lordship, the arresting authority arrested under section 3 clause 1, your lordship, but not complied with section 8 clause 1, your lordship.
Lawsuit, they task them also.
Tomorrow.
On task if it's correct. Sometimes also communication and
Yes.
Yes, my lord, leading counsel is out of station. Last night his maternal uncle was expired, so. So my lord, matter will fix this Friday.
What do you want to do?
Yes, my lord, leading counsel is my lord, out of station.
What
Last
do you
night,
want to do?
yes, his maternal uncle got expired, so he's unable.
When do you want to?
In this Friday, my lord, 31.
Friday.
Yes, my lord,
Thursday, make it Thursday, not Friday.
Thursday.
Also, it's represented on the prayer made by counsel for the appellant. List on 30. Please read.
Emergency case.
May I, your lordship? May I please, your lordship? Lordship, no. There was one IA for condonation of delay. That was
Yes.
But सबका नाम ले लीजिएगा.
and Anju.
For the land council for the applicant, public appellate. Also heard Mr. Tapin, the senior government advocate for the opposite party number 1 and 2. And
One.
Mr. 1 and 2.
One.
And Mr. S.K. Deori for the respondent number 3. 4, nobody is appearing.
Four, nobody is here.
The present application has been filed by the applicant seeking impleadment of Mr. Sri Bharat Rai and Sri Gopal Tuck as respondents number 5 and 6 in the present proceedings on the ground that their names were not arrayed as respondents in the appeal inadvertently. However, the said persons were party respondents in the writ petition, in the connected writ petition. Also, we have perused the contentions raised in the manner and on appreciating the fact that the respondents number on appreciating the fact that the above noted persons may be affected in the event any direction is passed in favor of the present appellants in the matter. Accordingly, the above noted persons are permitted to be impleaded as respondents number 5 and 6 in the connected appeal. Also, accordingly, the present interlocutory application stands disposed of. Appeal in view of the order passed today in IAC number 89 bracketed AP 2024. Sri Bharat Rai and Gopal Tuck are impleaded as respondents number 5 and 6. Petitioner to file an amended cause title in the matter within working days. Full stop. On filing of the said amended cause title, petitioner is permitted to take steps by way of registered post with AD as well as by usual process on the newly impleaded respondents number 5 and 6. Registry to list this matter again after 4 weeks on a date to fix.
Obliged.
There is one more, let this matter may be listed along with appeal number 32.
Everything is on review. It doesn't progress. Both quests gets delayed.
Any steps by APSC, APPSC in the matter after the order? No,
No.
it's pending.
Obliged.
We renew the prayer when the matter's service is over.
Over.
Then we'll tag it.
May I please, Your Lordship? I'm for the appellant, appearing as amicus in this case. Should the impugned judgment and order is at page 51 of the paper book. Starts at page 51. I will narrate the facts so that we don't have to go line by line. Lordship. May I submit, Lordship?
Just hold on.
The FIR was on 21/8/2014. FIR was filed by the son of the convict to the effect that his father was killed by his mother. The date of offense, according to the FIR, was at 9:30 hours at night on 18/8. That is 2 days prior. According to him, he was not at home when that incident happened. So the investigation had started, and Postmortem was also done on 21/8. That is 2 days after. Then Lordship, the witnesses who were examined were all the relatives, the son and daughters of the convict. 18/8. There is 18/8. Son came to know on 20. Then he arrived on 21/8. That is 2 days after. Then FIR was lodged at 4:30 in the evening. According to the FIR, the incident occurred at 9:30 hours at night, and that the father and the mother were alone in the house, the victim and the convict. It was alleged by the prosecution that the injury upon the victim was due to some sharp object and some blunt object. So accordingly, a dowel and 2 pieces of bamboo were seized, according to the prosecution. But it may be noted that the seizure witness did not identify that piece of material evidence, which the IO has claimed to seize. Now, Lordship may see the depositions. Starts at Lordship page 28 of the paper book. Yes, page 28 is the deposition of the informant, also the son of the victim and the convict. On oath, he says, I am appearing on being summoned by this court as a witness in the present case. On 18/8/2014, my father met with a fatal accident at Husugo. Mr. Sadin Disiso of Husugo called on my phone at around 1:15 a.m. on 19/8/2014, told me about the accident of my deceased father. I reached home on 19/8/2014 at about 6 a.m. and found my father dead on his bed at Husugo. I found injury on tooth and gums of my deceased father. On 28/2014, I informed the Rupa police. On 21/8/2014, dead body was taken over by police for conducting postmortem at Rupa. I cannot say if some injuries were inflicted on any other parts of the deceased. I could not gather evidence of that of my father. There was no other family member during the night of accident at home. At this stage, since his statement was not in accordance with 161, which he had stated before the police, the IO sought permission to declare him hostile and to cross-examine him. And he was therefore cross-examined. He says in the cross-examination by the IO, by the prosecution, I found neck, face, and left wrist of deceased were swollen. This is true. I state before the IO that the victim must have been assaulted with a heavy blunt object. I did not state that on the night of 18/8/2014, the deceased, in the bracket, my mother has quarreled with the deceased. The accused, my mother has quarreled with the deceased. I cannot say if my parents have ever quarreled during my absence at home. I have never seen them quarreling or fighting. Then he says, it is not a fact that the accused attempted to kill the deceased at any point of time prior to 18/8/2014. I cannot say if the accused has been a habitual drunkard before 18/8/2014. It is not a fact that my mother accused has killed the deceased. I have not seen the dowel at the PO. The accused is my mother. On advice of the villagers and family relatives, I have lodged a FIR against my mother at PS Rupa to know about the cause of the death of my father. At the time of the incident, she was the only family member present at home. P Exhibit 1 is FIR. P Exhibit 1A is my signature on it. In the cross by the defense, he says, I do not remember the author of the FIR. I do not remember whether the contents of the FIR were read over to me or not. I do not know if the deceased ever suffered high blood pressure. It may be possible that deceased suffered pressure stroke and fallen down over boulder or any hard object from the house. Then Lordship, sorry, there is more. I lodged in the cross by the defense. I lodged FIR against the accused only on suspicion and on the inputs from villagers. Deceased never revealed to me that the accused used to assault him. I cannot say if the accused was with the deceased or not at the time of his accident. The villagers did not tell me hearing about unusual noises at my residence on the night of 18/8/2014. There is no eyewitness of the accused assaulting the deceased. Accused is innocent. She has been implicated only because the accident occurred in her presence. Then, Lordship, page 31. This is PW2, and she is the daughter of the convict and the deceased. On oath, she says, I'm appearing on being summoned by this court as a witness in the present case. I do not recollect the date, month, and year of incident. My father died in the accident occurred at Husugo village. I saw his dead body at my home. The dead body was lying on bed. None of the villagers told me the cause of death of my father. On the day of incident, the deceased and the accused were at home. The accused is my mother. I do not know as to why she is standing on the dock. Then in cross by defense, he says, I have not witnessed the accused and deceased ever fighting or quarreling. It is possible that the accident occurred in the absence of accused. Then the next page, Lordship, page number 32. This is a nephew of the deceased, PW3, Jivan Sasuso. He says on oath, I'm appearing on being summoned by this court as a witness in the present case. On 18/8/2014, I was at my home, Husugo. I know the person standing on the dock. She is one of my neighbors. I do not know any reasons as to why she is standing on the dock. I did not see any police personnel at Husugo village on 18/8/2014. This witness was also declared hostile and examination was done by the prosecution. In the cross-examination, he says, on 18/8/2014, I was at Husugo village at 4 p.m. I have gone to Sakrin village of my grandfather. I know late Govinda Regiso. He is my paternal uncle. In the morning of 19/8/2014, I came to know late Govinda died at Husugo village. One of my friends told me that Uncle Govinda has expired on previous night. I never heard of the accused and the deceased ever quarreling or fighting on before 18/8/2014. The deceased and the accused have 3 children. I do not know who were present at the residence of the deceased on the night of 18/8/2014. It is not a fact that the deceased has killed the accused, that the accused has killed the deceased on the night of 18/8/2014. It is also not a fact that the deceased shouting for help on that night. Then in the cross by defense, he says, I have not seen the police arriving at Husugo village on 18/8/2014 to 28/2014. I have not given statement to the police in the present case. Then PW4, this is the younger son of the deceased and the convict, Sanja Regiso. He says on oath, I'm appearing on being summoned by this court as a witness in the present case. I do not remember the date, month, and year of incident which occurred in my house at Husugo. I do not know about the case. My mother has been implicated in the case because on the day of the incident, she was with my deceased father at home. Other family members and villagers, I do not remember the date, month, and year. I did not see the dead body carefully. I did not try to gather information as to how my father died. I could not collect evidence and cause of death of my father. I have never witnessed my parents quarreling or fighting during my father's lifetime. In cross by the defense, he says, I have not given statement to the police in the present case. Thereafter, Lordship, page 36, PW 5 is the doctor who had conducted the postmortem. On oath, he says, I am being summoned by this court in the present case. On 21/8/2014, I have conducted postmortem PM examination on dead body of Govind Regiso at CHC Rupa on police requisition. I have given the detailed information on my findings in the PME reports. Based on the findings, I opined that this deceased died due to intracranial hemorrhage. The PME was conducted after 3 days after death of the deceased. Lordship.
It's your lordship.
In this case, we find various loose ends. Correct. Now, which of the two items, bamboo and a dao,
Yes.
you think it is a weapon of assault?
Yes, your lordship. However, since there were no blood in the
No, that's okay, but we always go on a theory. We have a theory once we look at the evidence.
yes.
So how do you theorize? What do you think? We are not on whether you are right or wrong.
Yes, your lordship.
According to the evidence, what according to you must have been the weapon of assault?
As per the medical report, your lordship, it was by a blunt object, your lordship. Now, as in such a circumstances, your lordship, since your lordship is in this case, both the deceased and the accused were the only person in that house, your lordship, at the point of at the time of incident, your lordship. The explanation under 313 is very crucial, your lordship. She being the only person, she will have to answer and make an explanation, your lordship. However, her explanation.
We travel in a different route.
Yes.
You see, the incident occurred on 18/8 at about 11:30 hours. The FIR was lodged in the evening on 21st. Therefore, 18th is a day, 18th, 19th, 20, 21st. So, 4th day, even if we exclude the 1 day, which is because of the 11:30 p.m.
Yes.
So 3 days later on, the FIR is lodged. Now, this lady does not do anything to destroy the evidence. That means the dead body was kept
Yes.
so that the police can come, they can recover it, retrieve it, send it for the postmortem examination. Nobody said that she wanted to dispose of the dead body and the villagers stopped it. Nobody is saying. So therefore, she is not trying to destroy evidence. This one part. Second is, if you can please come to page 27.
27 is the charge.
It is a charge. Yes.
Yes,
Please read this firstly.
Yes, your lordship.
Correct. So weapon of assault is thou.
Yes, your lordship.
So therefore we exclude bamboo from here.
Yes.
Now, this intracranial hemorrhage. Intracranial means that in the brain between the parts, there's a bleeding. That's what is intracranial. Now, therefore, the wife does not assault the husband with a sharp side. Correct.
Yes, your
So intention to kill is not there. Because otherwise, she had the opportunity. He fell flat. And look, now if you can please come to page 23.
Yes, your lordship.
Eye is closed and swollen, bleeding from nose, cut injuries on upper and lower lips, 4 numbers of teeth broken
Yes.
in the lower jaw and jawbone broken. Now face is swollen, neck is swollen, hands are swollen, abdomen swollen. Now therefore, the impression gathered is that he fell flat. Only then these injuries can happen. You see, face, broken tooth and face and hand swollen. This is otherwise indicative of man falling flat.
Your lordship, if your lordship will see the
No, we are
space.
just theorizing. We are not saying anything. We are asking you questions. We are just theorizing
Yes.
what has happened because we have the evidence before us. So now we are just trying to see whether the evidence led so far leads to a conclusion that there was a murder. Because that we are not finding. Then the evidence on record is that the man while going to toilet, he fell and then he injured himself and then he died. Now the postmortem report that is at page 24 onwards. Cranium and spinal cord. The scalp lacerated on forehead, skull broken, frontal bone, depressed fracture, vertebrae anedi. Now it's a depressed fracture. Depressed fracture because you have to demonstrate that from the blunt side, if it is attacked, it would be a depressed fracture. You see, depressed fracture normally is that there's a depression caused. And with a thou, it's very unlikely. If it's a fall, then a depressed fracture is otherwise possible. We're just theorizing, we're not forming an opinion.
Yes.
Now, next page, page 25. Same thing. Upper lip, abdomen side. Upper lip, lower lip lacerated, 4 teeth broken. Because you see, now let us go back to our theorization. There's a thou in the hand. And how would the blow come? To have these injuries. Frontal, depression, jawbone broken, and then hands swollen. Because if I theorize, then this is not going to happen with a thou. Means a man has to be very, very calculative to put a blow here, to break the teeth, to break a teeth and jaw. The assault must be on the jawbone and the tooth. And when we are using the blunt side, if thou is not like this, then it is like U shape. So with that, how much of force would dislocate the both jawbone, break 4 tooth?
समय भी रहेगा देखिए वो भी
You've seen the LCR? You've seen the LCR?
No, your lordship.
There's a backflap covered. These are photographs. I just wanted to people see this. Detention. Yes, that is not it doesn't appear that after this, if there was a murder,
Yes, your lord.
then she would keep the body in the house, inform the son will come. And for 3 days, they don't do the cremation. They keep it. And you see, if the villagers also would have suspected something, he's the Gambura.
Yes, your lord.
The deceased is the Gambura.
Yes, your lord.
They would have definitely in this part of the in this region where they are residing, when the police station is 101 kilometer away from their village, there will be definitely some hue and cry in the village. Because in normal household, people would, just like we are theorizing, they will also think about what is happening, what is not. So they wait for the son to come and then they come to this police station and give an as a FIR.
Yes.
So that's what is, and you've seen the photograph of the dead body.
Yes, yes, lord.
Now, with a thou, we hardly doubt it would have happened. The simultaneous injury in the jaw and the forehead. The lady was examined under P13. And Just come to page 42.
Your Lordship.
This question number 9, is para 9. In the course of investigation, I took help of the villagers to locate the place of occurrence, which is inside the dwelling house of the accused and deceased. I found blood scattered over the place of occurrence. However, could not find use of any sharp weapon. I have recovered bamboo stick and dao.
Yes, your Lordship.
Now, you see the words used are the blood was scattered.
Yes.
Now, again, when we theorize this incident, blood scattered or splattered almost has the same indication. Now, when will you find, according to you, blood scattered over the place of occurrence? You see, the tooth is broken, jaw is dislocated, and then when there's cranial hemorrhage, that is internal.
Yes.
It doesn't come out. So, either from nose or somewhere, the blood will be out. But when there's a assault by a dao, the wounds has to be lacerated. Because even if from the blunt side, it is hit. What is the medical terminology? Supposing I am hit by a blunt weapon,
Yes.
we have this blue, what do you call, blue spot.
Yes.
The injury will come. What is the medical term?
I'm not. The,
You understand?
otherwise, it's a bruise. Is
A bruise.
bruises.
Bruise. But this page 23 and 25, that is not the impression we are gathering. Because if there's an assault from the blunt side, the death would not be instantaneous. It's only that cranial bleeding which went inside, what would happen is that would lead to a fatal cause of death. So there is only frontal region, there is only a compression fracture. So the cause of death would not be the tooth and the jaw, broken tooth and the jaw.
Yes.
It would only be the cranial,
Internal bleeding.
this bleeding. But then the lady comes to the doc and says that, well, this dao was in my basket.
Yes, sir.
Nobody said that this dao was recovered from the place of occurrence. No villager comes and says that there was any attempt to clean this dao.
If I may, Your Lordship, with regard to the seizure, if the seized weapons were actually not directly seized on any of the admission, but then it was given by the villagers, Your Lordship.
Because you see 1 feet, 1 feet or 1 meter bamboo, two pieces bamboo, and one dao of length 2 feet, including the handle.
Yes.
And this lady came and gave an explanation. This 106 has been explained in her evidence, DW1.
Your Lordship, at 161, Your Lordship. At what 161, Your Lordship?
Page
161.
Yes, Your Lordship.
Just a moment. In fact, before we come to page 14, you see, I'll show you something. Yes. Copy दीजिए ना. Copy. Sorry. Now here I'm becoming too technical. Now, please open page 22. No, this book.
Oh, yes.
22. 22 come to C. Courts of appeal and revision.
Yes, sir.
Now, Rule 15 says the records of the appellate and revisional court shall consist of only one file styled and marked as file A. The papers shall be arranged in the following order: title page, table of contents, order sheet, memorandum of appeal, copy of judgment and order, additional evidence, the papers, if any, in order in which they are filed, judgment and order.
Yes.
Correct.
Yes, Lord.
Now, this Rule 18. if any document is referred to in the proceedings or shown to a witness before it is tendered in evidence and formally proved, it should immediately be marked for identification. Now, 161 statement, I don't find it is marked for identification.
Yes, yes.
Correct. Now, please come to page 26. Rule 29. Documents not admitted as documents not admitted as evidence. Documents which are not admitted as evidence should not be made a part of the record, but it should at once be returned to the party by whom they have been produced. Now,
Yes.
therefore, if I can again show you the CRPC. One 72 CRPC.
Yes, your lord.
Diary of proceedings in investigation. 172(2). Any criminal court may send for the police diaries of a case under inquiry or trial in such court and may use such diaries not as evidence in the case, but to aid it in such inquiry or trial.
Yes,
Correct.
yes, your lord.
So therefore, my impression of the provisions which I have shown you, read with this CRPC, is that 161 statement can be used otherwise for the purpose of
Corroboration.
either corroboration or contradiction. Nothing more than that.
Yes, yes, yes.
Therefore, once that is not a part of evidence, you see, ideally, what should happen is that for the even for the purpose of contradiction, that passage of the 161 statement should have been incorporated in the evidence, and the question asked for the purpose of contradiction would have been to introduce that part of the statement into the question. That was not done.
Yes.
So therefore, 161 statement, you have to make some convincing argument for before this bench to read this 161 statement.
Yes. Your lordship, the prosecution here have not relied upon 161, your lordship.
That's why, you see, once it is not relied, why will the appellate court? That's why I said, before this bench, you'll have to make more convincing argument to make us read 161 statement.
Yes. Yes, sir.
Why should we read 161 when it is not a part of trial?
Yes, sir.
That's why I said we'll be too technical now,
Yes, yes, yes.
but the technicality is introduced just for the purpose of upgrading your skill as a additional public prosecutor. Correct. You must know the scheme of the provisions. Therefore, we have taken you there just to upgrade your skill, nothing more.
Yes, yes, sir.
Because here this law is now being developed.
Yes.
So perhaps your exposure to this aspect of the matter may not, maybe there may not have been there. So I'm just thinking aloud so that in the process of interaction, you upgrade your technical skill.
Yes, sir.
Correct. So this is why we say that you have to make some more convincing argument to make us read 161 statement. This one. Now, the second part,
Yes, sir.
you see, when the charge itself is of the DAO, you'll have to establish something to some convincing evidence to be brought on record to connect DAO with this death. Has the prosecution been able to do so?
Mm.
To link this weapon of assault with the cause of death.
Your
See,
Lordship,
the doctor was asked the question. He said that he did not, what do you call, the death would not have been by falling down.
yes.
Correct. But the theory of the thou being assaulted, that was never put. Therefore, this to establish this as a weapon of assault, you're not finding any evidence. Can you look at any evidence to show us?
Yes, yes, Your Lordship. Your Lordship, if I may, Your Lordship.
Yes.
Even otherwise, seizure or non-sending of a weapon would not be fatal if the circumstantial of the evidences of the witnesses as well of the other evidences would be very strong, overpowering to non-seizure or non-sending of the weapon to the FSL, Your Lordship. Now, if I may take Your Lordship to the statement of the PW1, Your Lordship, which Your Lordship will find at page number 28, Your Lordship. Now, if I may briefly with regard to point number 2, Your Lordship. See, Your Lordship has pointed out that after 3 days, the report was sent, Your Lordship. However, the incident was reported on the very next day, the son came, Your Lordship, and he had seen the father, deceased father, Your Lordship. Thereafter, he had, on being suggested, Your Lordship, he has filed an FIR, Your Lordship. After the FIR was filed, thereafter, the body was taken by the IO, Your Lordship. Now, Your Lordship, since even the son, the children were very much present on the next day when the incident happened, Your Lordship. That therefore, the question Your Lordship has put up, Your Lordship, with regard to that she had, if she had any intention, Your Lordship, she would have done something with the, or hidden the body or made any kind of such act, Your Lordship.
Aspect.
Yes, Your Lord.
You see, there may be a circumstances where the wife could not dispose of the dead body. It can only happen when the villagers are there
Yes,
guarding that dead body
yes, Your Lordship.
or in the room. The son coming in does not say that when I came in, there were villagers in my house.
Yes,
He said that I came in, I saw my father lying.
yes, Your Lord.
Therefore, it's not that the women did not have a scope of doing it. But this shows that she had no fear of anything because she may not have done anything. So that's why you see that those evidence blood spattered.
Yes,
The police came after 4 days or 4th day he came.
yes, Your Lord.
21st, 18th, 21st, 18th, 19th, 20, 21st. If we take the date of incident, if we exclude 18th, then it is 19, 20, 21st, 3 days. The lady did not make any attempt to clean up that mess.
Yes,
Correct.
yes,
So that displays that she is not a guilty mind. Otherwise, this blood would have been removed from that place. She left the evidence as it is. The police could have collected this and sent it for forensic examination. That was not done.
yes,
The seizure of thou, it does not say from where it was seized. Come to that seizure list. Seizure list is page 15. You see, the seized properties are also of the position of is not there, house of so and so, not there. It was seized and it was sealed in the presence of witness. Therefore, the dhow is not hidden.
Yes.
But when it comes to this bamboo, she gives a statement, she doesn't know about the bamboo.
Yes.
Dhow, she said, yes, it's there in the,
Basket.
so she does not make any attempt to hide it. And in village, dhow is a weapon which will be present in every house.
Yes.
So the availability of dhow in the house is not very strange. In the locality where the police station is 100 kilometers away and she's a villager. We don't find that there's any circumstantial evidence also to link this.
My lordship, my submission is only with regard to, since all of the witnesses were declared to be hostile, your lordship. My only basis of argument is on the statement under 313 and her defense itself, your lordship. That under 313, certain explanation has to be made if
One midnight, so Margin all around the village. The people happen was totally come up with moving the social immediately within half an hour, she came to me. One meeting. So 11:30 that's like 11. So within half an hour, how can things? They could move the action to make it सवेरे उठ के देखते क्या हुआ तब जाके तो it can go under this but of doubt naturally वो आपको बोल रहे हैं उसका अगर ये कुछ ना करना है तो बॉडी की सफाई करते हैं तो दूसरा क्या काम चलने और बीच में देखना दिखा सकते अगर वो एक्सरसाइज करता है वो देने दे इतना खाता घंटा तो तब भी उसको एग्जामिनेशन में कुछ तो नहीं पता कुछ तो नहीं.
Yes, there's one circumstance which I missed. My brother has rightly pointed it out. We come to the evidence of PW1. PW6, PW6.
38.
Paragraph 2.
yes.
I don't recollect the date and year of the incident. One midnight, so and so shouted Mar gaya, all around the village. I, along with other residents, rushed to the village and so dead. My Wazim was alone in her house. One place, what is called in one document, it is said that the time of incident is 11 p.m. But in the FIR, it is 11:30. Correct.
In the inquest report, Lordship.
Huh?
In the inquest report,
It is
11:30.
11:30.
11:30. In the FIR, it's 9:30. In the charge, it is 9:30.
No, 11:30.
In the charge, Lordship.
No, some document 18.
11:30 is Caesar, sorry,
No,
the
you
inquest
see,
report.
No. In the inquest,
Yes.
in the inquest, it is 11, page 23. Date and time of death is 18/8/2014, 11.
Yes.
Correct.
Sorry, Lordship. Yes.
So one document it is 11:30, and this witness comes and said that at 12 o'clock she started running and entire village and said that he died. Therefore, you see, if there was a guilty mind, she would have cleaned up the place, at least the traces of blood. Washed of the face or something to make it more decent, to make it appear as if it was a natural death. But she did not do those things. So guilty mind is not there.
Uh,
And what is your circumstantial evidence? You are saying that there are circumstantial evidence.
Yes,
Please
Your Lord-
complete that part.
Yes, Your Lordship. The first circumstances being that both the husband and wife at that point of time was in the same house, Your Lordship. Other than them, no was present. She was the only eyewitness, Your Lordship. Now, since she being the only eyewitness, Your Lordship, she will, under 313, there need to be, any question put up to her, there need to be a clarification, Your Lordship. If she states that my husband has died falling on the ground, Your Lordship, no one under 313, even though the question was put up, Your Lordship, no one, nothing under 313, nor under her own evidence, Your Lordship. Defense evidence number 1, Your Lordship. She has made any explanation, Your Lordship.
313, where is that?
At page number 70, Your Lordship. Starts from page number 70. I DPD of 70, I think.
No, something is wrong. 45. 45. No, 45 is post that evidence.
Your Lordship.
Page 45
Yes, Your Lordship.
is post DW.
No, prior to DW.
No. You see question number 6, page 45.
Yes.
Since you have admitted in your defense that you had not seen any person visiting your house. So it is after defense witness.
Yes.
This is post defense witness.
Your Lordship, oh yes, Your Lordship, deeply apologize. Your Lordship will see this page number 45.
46, page 46 is the 313 statement.
Yes, this is also, the page has wrongly been.
It's okay.
This question number 6 is the reason for, since he was in her custody, the reason for his death and the injuries sustained, Your Lordship. She denies knowing anything about the injuries resulting
No,
to the
that's
death,
okay.
Your
You
Lordship.
see, there's a reason for that.
Yes, Your
But
Lordship.
page
Now,
40, page 46, come to the answer. Last question 1 answer.
yes, Your Lordship.
Last 2 lines. I was present in the kitchen at the time of death of the deceased. The deceased chased me away from the house.
Yes, Your Lordship.
Correct.
Yes, Your Lordship.
So she was present in the kitchen.
Yes, Your
Now
Lordship.
she's also stated somewhere that although they are living in the same house, but she's living in a separate bed.
Yes.
Correct.
Under 313, Your Lordship. Under the, in her defense, Your
Whatever
Lordship.
it is,
Yes.
somebody is there that she sleeps separately.
In this context, Lordship may also please see page 20. This is a sketch map. Here, apparently, the kitchen is in the outer part of the house.
Kitchen is outer.
Yes, page 20. Even though it is the same house, it's in the outer side. We have houses like this here, where they have separate kitchens from the main house. Since they were sleeping in separate beds in separate parts of the house, it is quite possible that she might not have known. Page 20,
The dead
Lordship.
body is in the kitchen.
Yes.
ये तो किचन है, ये तो किचन है, ये किचन है ना। वो हम लोग का- See-
no, one thing, the decision of the learned district judge,
Yes,
if you go through that, he has tried to make out a chain of circumstances.
yes, Lord.
Now, if you come to page 72 of the paper book,
Yes, Lord.
uh, G,
Yes,
seventhly,
yes, Lord.
the weapon of offense and the evidence of respondent PW5, doctor opining that the weapon of offense used in the crime are also matched. You have taken us through the evidences
Yes,
of PW5. He has not referred to any particular weapon. From where did the learned judge get this?
uh,
And another thing,
I assume that this is only with regard to that blunt object, the word blunt
we
object.
can't assume. We
Lord.
can't assume.
Yes, Lord.
It's a person's life. We can't assume,
Yes,
right?
Lord.
And again, if you come to H,
Yes, Lord.
we have seen the evidence of the investigating officer, blood spattered,
Yes, Lord.
right?
Yes,
But whether that blood was spattered in the bed or in a different place,
yes.
that is not.
We are not being able to find only two things. Number one, which is the place of occurrence,
Yes, Lord.
correct?
Yes, Lord.
Now, the dead body was found in the kitchen.
Yes, Lord.
The wife comes and deposes that the husband might have gone to the, while going to the toilet, must have fallen.
Yes, Lord.
So kitchen is not a place where you will find toilet.
Yes, Lord.
The second is, she says that the last line is that the husband drove her away from the house.
Yes.
Now, she again says she was in kitchen at the time of death.
Yes.
So therefore, they are both in the same room.
Mhm.
But the circumstances of that death, we can't gather from there, because we find the dead body is on a
Bed.
on a bed.
Yes.
Correct. Now, in this photograph, we are not very certain. You see this?
Yes. Yes, Your Lordship. Below is the bamboo ground, Your Lordship.
No, because since we have no experience in village homes, so we can't just say, what is this?
Yes, Your Lordship. It's normally
No,
kitchens.
this
the
is
kacha-
this kitchen.
Yes, yes, Your Lordship.
Now, in that kitchen, the first, yes, this one.
Yes,
The first, the second one.
yes,
Second picture.
Yes.
yes,
There is a bed, and there is another, on the extreme left, we find something. This is not usual in a kitchen. So I think that is also a bed.
Your Lordship is referring to this bed out here, Your Lordship.
Yes, the woman is sitting.
Yes, yes,
Then on the right side, you find something else.
yes, yes. Your Lordship, if I may, Your Lordship, normally in villages, Your Lordship, these are the houses, this type of the kacha houses where there is, sometimes there are no separate room, even in the kitchen, kacha kitchen, Your Lordship.
No, but she's demonstrated from that inquest report, there is a house
Yes,
and this is a kitchen.
yes, Your
Now
Lordship.
in kitchen, we are finding two bed,
Yes, Your Lordship.
correct? On
Yes,
the right side also, there appears to be a semblance of bed, but we can't say because I have no experience in village houses here.
yes. Your Lordship, these photographs, Your Lordship, this is the photograph, Your Lordship. This is the house as well as the kitchen, Your Lordship. Seems.
No, but in inquest, you see, there is different too.
Yes, inquest, I have, that's why I was also asking the amicus that if Your Lordship sees
No,
the,
but no, I've given that for purpose.
oh, sorry. Dada,
Just
Dada.
give it to her again. No, this one is a bed where this dead body is lying,
Yes,
correct?
yes, Lord.
The second, we said that the second part we are not getting it, that the police found the blood scattered where? Because you see the dead body is now in a bed. And that right side, we still have that query, whether it is a bed or it's something else. The woman is sitting,
Yes, yes,
on her right, extreme right.
yes, yes, your
There's
lordship.
an elevated thing.
Yes.
It's not a kitchen apparatus. It appears to be a bed.
Yes, your lordship. Because there seems to be some blanket or something upon that.
Huh. So in the kitchen, there are two beds, that means.
Yes, your lordship.
So dead body is found in one.
Yes.
And she says that
We were sleeping in different beds.
story introduced is that they both were drinking.
Yeah.
The son comes and says that whenever my mother drinks, she assaults the husband.
Yes.
Correct.
Yes.
So that means both of them are drinking, and then she says that we don't know what had happened. It's quite possible.
Yes.
So these are the two things, missing links.
Yes.
If
Even-
the wife is right, if the husband drove her away from the house, she was in the kitchen, came back in the kitchen and somehow died.
Your lordship,
That is pattered.
even in her, if your lordship has, she only states that we slept in different bed, not in a different room, your lordship, or not in different part of the household, your lordship. Yes. Your lordship, if I may also take your lordship to, lordship, if I may take your lordship to,
So she was chased away from the house, and nobody,
Yes.
that's not questioning. That
Yes.
means she is not in the house, she is somewhere else.
yes,
So therefore, kitchen has to be outside that house. Which Ranjan is saying.
yes. Though she seems to have been chased out, your lordship. However, her defense clearly states that at that point of time, they slept in different beds, your lordship. And I'll just take your lordship to one very
Also in the bed, and there is no evidence that in this case, activity pleasure, the pleasure becomes the feature of the bed. So it's not good, now it's better there. They have not seized that.
Yes.
Yes, your lordship. I would just like to place a judgment, since I'm relying only on the evidence of 313 and the evidence of the accused, and the very she could not explain a plausible explanation with regard to the injury sustained and what has caused the death of the accused, your lordship. Because as per her own statement,
Madam, there are two things.
Yes.
Number one is not being able to explain
yes,
the circumstances. And second is an evidence of, you see, beyond reasonable doubt.
yes,
Now, are you trying to say that the circumstantial evidence is so overpowering that you don't have to prove that that beyond reasonable doubt theory will not come? It is only the circumstantial evidence. Correct?
yes, your lordship.
Yes, then show us the judgment.
Your lordship, prior to that, your lordship, with regard to the, your lordship has read upon the statement of PW6, your lordship, where there was he has said that on midnight she has shouted marga, meaning thereby that his death was prior to her calling up the neighbors that he has died, your lordship. And therefore, even the time 11:30, your lordship, it was given. I'll just place a small this, your lordship, because other than that, your lordship, at Yes, Your Lordship.
Yes,
Your Lordship, down below is the page number, Your Lordship, page 11,
page 11.
the second last page, Your Lordship.
Yes.
The paragraph 16 and 17, I would like to rely upon it. Now, if I may read, Your Lordship.
Yes.
In a case based on circumstantial evidence where no eyewitness account is available, there is another principle of law which must be kept in mind. The principle is that when incriminating material is put to the accused,
Just a moment, again, disturb you for a moment. You see, before you apply this or Sharad, Vidishan, Sharda,
yes,
first thing is that you have to show that there is a chain,
yes,
correct? The chain would be here, that the weapon of assault, the nature of injuries, which matches, correct? And then you have to also demonstrate that it could have been inflicted by the wife. You see, two things, kindly note. In that photograph, you look at the structure of the wife and the structure of the deceased husband. Not to use that dowel with such a force to inflict that injury, because you see, one or two things. Number one, with the nature of injuries that the deceased had, the postmortem report and the inquest report reveals the injury suffered, would be that more than one assault has been made. Correct?
yes,
In the head, in the
jaws.
in the nose, in the hands. You see, swelling in the both hands. Very unlikely that when somebody is assaulting, the injury would affect the same part to cause similar swelling in the rest of the deceased. But when we think of a theory that he must have fallen flat, then these two injuries are explained. The injury of the jawbone and the tooth is explained. So only one remains, that is the head. So because then again you can establish that if this theory is there, then the wife could have given a single assault on the brain with the blunt side of the jaw, and then internal cranial bleeding would have happened. Correct. But if these two nature of injuries remain, then you'll have more burden to show that, because the medical evidence is only intracranial bleeding has led to death. The other injuries can be, for the time being, say that it was a grievous assault, maybe 325, 341 or something.
Yes,
So there's only one possible theory of that woman giving a blow in the head. Then again, my brother told you that blood spattered. From where the blood splatter was there, we don't know.
yes,
The evidence was not collected.
yes.
So
Yes.
therefore, where is the complete chain?
Your Lordship, my,
To apply this Maruti Nandan or Sharad Bidhi and Sharda.
Your Lordship, the chain I drew is, Your Lordship, as per her evidences, Your Lordship, of the accused, Your Lordship. On the day they were both together, Your Lordship, the husband was very drunk, Your Lordship. They had a quarrel, Your Lordship. Thereafter, nothing is known, and the last was when she revealed to the villagers that her husband has died, Your Lordship. In between, Your Lordship, the gap of after, when he was so drunk, they had quarrel, Your Lordship. Thereafter, the missing part, Your Lordship. Since there was no eyewitness and it has to be only explained by the accused, Your Lordship. Now, Your Lordship, on the first occasion, Your Lordship, if I may read again, Your Lordship, there are also under 313, she clearly admits that he had threatened him to kill for torturing an unnecessary allegation to have committed adultery out of anger. The motive shows, Your Lordship.
In the judgment also,
Yes,
he had, the judge had taken up around 7+ points to make that chain.
yes, Your Lordship.
I've taken you to G.
Yes, Your
So
Lordship.
there is a break there. Page 72.
Yes, Your Lordship.
If you come to H, the next part, next page,
Yes,
second line. It leads to tell this court that the accused had attacked the deceased sometime after quarreled, while the deceased was either resting or sleeping in his bed. So the learned judge has taken the bed to be the place of occurrence.
yes,
So if blood was spattered, we see the Caesar memo,
yes,
the bed sheets, those where the blood was in, were never seized.
yes, Your Lordship.
And the IO also does not say that the bed was the place of occurrence. He just makes a reference to a place of occurrence.
Yes, in that regard, Your Lordship, I deeply apologize. I would like to draw Your Lordships to page number 44, Your Lordship. At page number, serial number 9, Your Lordship. The last sentence, Your Lordship, I did not draw the separate PO showing the toilet. So if I take the entire sentence, Your Lordship,
But there is a place of occurrence.
yes,
There is blood spattered found. Where?
yes, Your Lordship, that has clearly not been,
That, the weapon, both not there. So how do you say that the,
in fact, the entire village was taken as a place of occurrence at serial number 5, Your Lordship.
in this case, the strangulation plus the burning were related with the letters written. And then the Supreme Court said there can be no other.
Yes. Lordship, my only argument is only on the Your Lordship.
Because you see, just one part, then we'll come to some other thing we are looking at. You see this, my learned brother told you about the circumstances.
Yes,
Now, if you come to page 67,
yes, Your Lordship.
in the middle, during recording of statement, the accused stated before the IO that the deceased fall down in the ground and sustain injuries, but the IO did not find any evidence of blood stain of the deceased falling on the floor.
Yes.
Therefore, where was the blood splatter found?
Yes, Your Lordship. In fact, I was showing the same at page number 44, Your Lordship.
Yes, 44, we are there.
At serial number 9, Your Lordship. If I read the entire context, Your Lordship. On my inquiry, accused stated that on the relevant time that deceased fell down on ground on the floor and succumbed to his injuries, but I did not find any trace of blood or any other evidence of the deceased falling on the floor. Therefore, I did not draw the separate PO showing the toilet. So
Now, you see, that means the only theory can be that the blood spatter was on the bed.
Your Lordship.
The blood splatter
Yes,
was only on the scattered blood,
yes, Your Lordship.
was on the bed,
Yes, yes, Your Lordship.
but that bed was never seized.
Bed sheets were not seized.
We just want you to complete the chain, at least one chain somewhere, either the place of occurrence or the manner of assault.
Yes.
Because then the case would be, if the police is, if the IO is right, then the husband is sleeping on the bed. Now wife comes and gives a multiple attack,
Yes, Your Lordship.
correct? The jaw is broken, the tooth is broken,
Yes.
the intercranial, this,
Yes,
but you see, swearing in both hands,
yes, Your Lordship.
it's not matching.
Yes, Your Lordship. Your Lordship, yes, in fact, those are only the, since I have already stated, Your Lordship, submitted, Your Lordship, that after they had a quarrel, Your Lordship, the point where this happened, Your Lordship, and the subsequent calling of her neighbors about the deceased person, Your Lordship, this is where the explanation, the place of occurrence, because everyone whosoever came to see the deceased, they all found him on the bed. But as per her statement, as per the IO's statement also inquiry, her statement was that he had fall down in the floor of the toilet, Your Lordship. Now, the statement of her itself is contradictory, Your Lordship. She has not given a plausible explanation.
You see, if the IO would have given us the place where the blood was scattered,
Yes,
everything would have been clear.
yes, Your Lordship.
No, that is not given. So therefore, really, the wife is saying that he might be going to the toilet. So therefore, the toilet is not within the kitchen.
Yes, Your Lordship.
Normally, it is not there.
Yes,
In
Your
kitchen, you don't find toilets.
Yes,
So therefore, you see, the suggestion given that the was going to the toilet does not mean that it is within the room.
yes.
Toilet may be elsewhere. The toilet is not even the shown in the map,
Yes, Your Lordship.
in the sketch map. So
Yes,
therefore, we are not finding a chain, complete chain under the circumstances,
yes, Your Lordship.
even for one part. In a chain of circumstances, there would be several chain.
Yes, Your
Number
Lordship.
one, the what you call when it's a case of circumstantial evidence, the motive must be established.
Yes, Your Lordship.
So this is number one, that to construct a chain for motive.
Ye-
The second is the weapon of assault and the matching of the injuries.
Yes,
Although the trial court has recorded that, we don't find that chain is present.
yes,
The third is with regard to the assault and the place of occurrence.
yes, Your Lordship.
This is the third chain. Because the weapon of assault was not done, she rightly or wrongly, even to camouflage, she runs in the village and tells that the husband has died. The weapon of assault, that is the dao, she did not make any attempt to hide it. So if it would have been a case of where the attempt to hide this weapon of assault, if there was a recovery under 27. So we don't know. Now once this police says that we recovered it from the house, it's not of the instance of the accused. Therefore, it must be an independent evidence.
Yes,
Otherwise, if it is covered by section 27 recovery, then that part of the explanation is not required.
yes,
Now, you have to also bring in evidence to show us that the dao is a weapon of assault. Because it's found somewhere, from where it is seized, it's not there. So again, there's a break in the chain. These are the circumstances we are telling you. We'll take a 5-minute break and come back. Just address on this chain.
Your Lordship, with regard to place of occurrence.
Yes,
Yes, Your Lordship, only at page number 42, Your Lordship.
42.
Yes, Your Lordship has on the previous rightly observed that there is no specification as this bedroom or the kitchen or anything is a place of occurrence, Your Lordship. Your Lordship will see only the entire house was taken as a place of occurrence. If I may read, Your Lordship, in the course of investigation, I took help of the villagers to locate the PO, that is the house, which is inside the dwelling house of the accused. Now, if I may take Your Lordship to also point number 5, Your Lordship.
Not spattered, awardly. Word did not find use of any sharp weapon.
My brother is right. In fact, when you are reading this 42, now
Yes.
there's a doubt as to the place of occurrence. You see, same thing, page 42,
Yes, Your-
para 9.
yes.
In course of investigation, I took help of the villagers to locate the PO which is inside the dwelling house.
Yes,
Now, if that this trace map is correct,
yes,
then the kitchen is outside.
yes,
So the IO located the place of occurrence inside the house.
yes,
But unfortunately, that evidence is not there.
yes.
No, this is not the kitchen.
This is not
Therefore-
the kitchen.
Therefore, what has happened? Now, again, we are just theorizing for a moment. We have seen the lady. Correct. The lady photograph, the lady is there. We have seen the husband. Deceased. Now, from the place of occurrence, she would have dragged and brought the body to the kitchen. Make it lie there.
Yes.
Very unlikely. And then she would run, inform the village that this has happened. She won't. It's very unlikely. Instead of making out a chain, we find that it's more broken.
Yes, in fact, Your Lordship, with the statement of the IO stating that on inquiry to the accused, she had stated that he fell down in the toilet, Your Lordship. That is also contradicting to her own
It's
statement.
okay, you see, somebody in this court campus, say, fell down and got an injury.
Yes, Your Lord.
Now, the reporter comes and asks me, sir, what do you think? What did happen? So what did I say? Maybe from coming out from the toilet, he has slipped.
Yes, if coming from the toilet, Your Lordship.
No, I understand, but you see, that's just beside the point. The point where I'm trying to show it to you is that if you ask somebody, it's merely an opinion.
Yes,
Opinion is not an evidence. The
Yes.
wife says that, well, he might have fallen from the toilet.
yes,
It's merely an opinion.
yes,
Now, let us say that this opinion is incorrect. I will have to say that this incorrect opinion was given to mislead the investigation. And therefore you complete the chain. That's it. That's the point which I'm trying to understand from you. So therefore, the intention of a false statement by an accused person was to mislead the investigation. I does not say so.
yes, yes,
Therefore, whatever is the explanation of the wife, you may accept it or you may not accept it. If you accept it, it's evidence again under 106.
Yes.
If you don't accept it, it's a unlikely theory and therefore you are not accepting it. But then the conviction must be made on the basis of this statement, relying on this statement saying that it was a false statement given to mislead the investigation, and therefore under 106, she could not discharge her what do you call the duty to place the evidence, which was available.
Now, your lordship, if bringing that part apart, your lordship, taking that part apart, your lordship will see that in her 313, any question put up to her, your lordship, there is no explanation. She being, she had first seen the dead body, your lordship. She cannot explain as to where did she find the dead body. Was it on the bed or on the floor? So,
Please. You see, we'll have some difficulty in understanding that. We'll tell you why. Now, it's for the prosecutor to tell us where the dead body was there. Then that becomes an incriminating evidence against the accused person.
Yes.
And she is accosted with that incriminating evidence under 313. Then it is her duty to discharge that by within the meaning of section 106. So it is not the primary evidence of the accused to tell us where the dead body was there.
yes. That's why, your lordship, in such circumstances where there are no eyewitnesses.
No,
Do you know?
you're not an eyewitness. Please please understand. With the statement made by you, we gather it that it was the duty of the wife to tell us where the incident happened. No. That is the duty of the prosecution to tell us. When the prosecution establishes that, then she'll have to give an explanation of how did that could have happened. So it's not the primary duty of the accused to show where the place of occurrence, because that is an incriminating evidence and she is protected. The accused is not has no burden to tell us how things happened. She has a right to remain silent.
Yes.
Now it is only she has a right to open the mouth when it is an evidence within the meaning of 106. So therefore, we find it a distinction. If the prosecution shows that the place of occurrence is X, and then she'll have to explain what happened in X when she was there.
Yes, your lordship. Your lordship, if we see that since the IO has also pointed out that the exhibit of the place of occurrence was also photographs was taken, your lordship. And if we see the photographs, your lordship, that is the house, Kacha house, your lordship. The IO has, if your lordship will
But the
come,
dead body is in kitchen.
kitchen, your lordship. Now, your lordship has seen two beds in the kitchen, your lordship. One where the accused is lying and one the empty one.
No, but kitchen is not the house. You see, that's the difficulty we are having. That's why we said kitchen is incomplete. Come to the
20.
request. This rough sketch map. House is shown. After that house is a kitchen.
The lordship,
Page 20. House is different, kitchen is different. In the kitchen, there is a dead body.
your lordship, your lordship, if sees the photograph at page number 41 at serial number 6. I have
41.
examined and recorded the statement of the complainant and 4 independent witnesses as PO. I have also taken the photographs of the PO, your lordship.
So therefore, this room, wherever this photograph is taken, is the place of occurrence.
Now, if your lordship will see the PO, which is inside dwelling house at paragraph 9, your lordship, it's inside the dwelling house, lordship, of the accused. Page 42, your lordship. If your lordship read serial number 6 along with 9, your lordship.
So place of occurrence.
Yes.
So therefore, if this is the place of occurrence,
Nahi hai citation.
then if we read para 9,
Yes, your lordship.
occurrence is inside the dwelling house. It's not the
Yes.
kitchen.
Yes.
So somebody has brought the dead body in the kitchen and placed it.
Yes, that's why, dear lordship, what I'm trying to say is that mid-chain, your lordship, which is broken, your lordship. My citation before your lordship is only with regard to that. In such circumstances where there are no eyewitnesses, your lordship, and only 2 persons stay, your lordship, and were present at that point of time, your lordship. If I may read paragraph 16 and 17, your lordship.
Yes, para 16.
Yes. If I may read, your lordship.
The principle is that when an incriminating circumstance is put to the accused and the accused either offers no explanation or offers an explanation which is found to be untrue, then the same becomes an additional link in the chain of circumstances to make it complete.
Yes. At paragraph 17 also, your lordship.
Now, with this, which part of the evidence you are trying to show that this is chain is complete?
Your lordship, as per the chain, your lordship, of the evidence, your lordship, both of them were together, your lordship, in the house, your lordship. Had quarrel prior to the incident, your lordship. The accused has also intimidated the deceased, your lordship. Thereafter, the chain, the chain was missing, your lordship, and thereafter, she is the first one to see the dead body and then shout for the help, your lordship.
Yes.
Yes, your lordship. That non-explanation of that particular period of time, your lordship, because she was there, she was the first person to see the deceased, your lordship. If anything happened in the house, your lordship, she did not give any explanation, your lordship.
No. You see, please come to paragraph 16 again.
Yes, your lord.
The principle is that when an incriminating circumstance is put to the accused.
Yes.
Now, where is this incriminating circumstance put to the accused?
Yes. The questions under 313, your lordship.
Yes. Yes.
At question number 6, your lordship.
Question number 6, yes. Page 48, yes.
45, your lordship.
45. No, this is not incriminating. Now you see, let us forget this for the time being. There's a road accident. Correct. Somebody reported this road accident. Now police is inquiring with him that, you see, 3 days back you had a quarrel with this man, who is the person who was killed in the road traffic accident. Now, on this particular day, there was an accident which occurred. And and you were also found in the vicinity of the accident. And therefore, please tell us what has happened on that day. He said, I don't know what has happened. Yet you see the evidence is, as the deceased was under your custody in the house.
Custody. Yes.
Custody would mean here.
Yes. Since even the accused denies that anyone visited their house, your lordship.
No, that's
On a
okay,
part of
but
time,
in
yes.
the custody means she's The custody is some sort of restrainment. Custody.
Yes.
And then she is asked that, can you tell us how he sustained injury?
Yes.
So this is not 313. You are asking an inculpatory statement to be made. In 313, the question is that you tell us what has happened. I don't know what has happened. So this statement is not shown to be false. This statement is not shown to be misleading. Therefore, Maruti, which you are reading, how it can make a chain? You see, you are asking an incriminating question. She has a right to refuse to answer. Now, if I ask in 313, now do you admit that you are murdered? And she said no. Although he was in the house with me, but I am not murdered. So will it be taken to be a statement where under 106 she should have read an evidence? No. But here you see the statement, because under the custody house, can you tell the court how this is sustained injury? If I have not seen, I can't say, even if it has occurred in my house. My bungalow plan is in the house. Today morning, while cutting vegetables, he snipped his finger. The rest to me, I gave a band-aid. He applied a band-aid and then he is out. Now, if you ask me, sir, this man came to you running, he told you that he has cut his finger, you just applied the band-aid. Now, please tell me, how did he cut? How did it cut? Would mean that I was an eyewitness to that cutting. I would say that I don't know. Yes, I applied a band-aid. I gave him a first aid. I put a Dettol, cleaned it, put up a band-aid. But when you are asking me a question, how did that happen? I would say I didn't see it because he was in the kitchen cutting vegetables for my breakfast. I'm giving today's evidence. It's only storytelling. I'm a good storyteller, so I tell stories. Now you see, this is something which can't be explained. At times, when I was driving scooter, I get injury somewhere in the leg. In the evening, I tell my wife, I got an injury. I don't know how. I don't even remember hitting someone or getting an accident. I don't even remember. But yes, I have a pain. And this is indicative of that I suffered an accident. So therefore, my own injury, I don't know. I can't introspect and say, how did that happen? Suddenly in the morning, I wake up, I can't lift my hand. There's a frozen shoulder. Doctor asked me, how did it happen? I can't tell him. In the morning, I woke up, I found that there's a frozen shoulder. I can't tell doctor how it happened. Because you see, we want to know from you the change circumstances has to be complete. We are going slow, I told you. We want to upgrade your skill, that's why we are going slow.
Yes.
We are trying to find out from you. If the change for a moment is complete, then we'll accept it. But we are not finding anything. This statement itself, I don't know how the learned judge has asked me. Can you tell the court? You should know, not that. You have to introduce this evidence could have been said that you see, you are the only person and he got injury in your presence and at your instance. Do you have anything to say? Then you are putting an incriminating question to him that you were alone in the house, you caused that injury, he fell down at your instance, at your hitting, and therefore this is the blood was found splattered, and then you say, do you have to say anything? So that is an incriminating evidence laid before the same thing. I'm just reading the same paragraph
Yes.
in a different context. If this question is asked, and then if you are asking the accused to tell us, do you have anything to say? Then this explanation should have come from her to dispel that incriminating evidence against her. Because now you're putting a complete chain. That you alone were in the house, you had a quarrel, then you assaulted him with a dao, blood found splattered. And then what do you have to say? You are in the, both were in the, though in a different bed, but you are the only persons in the room.
Yes.
If this is the question asked, then if there's no explanation, then you see Maruti Nandan. It completes the chain. Then it says it's an additional link
Yes.
to the chain. So it doesn't say that you complete the chain. It says it's an additional link. 106 is the absence of explanation under 106 is an additional link.
Yes.
That is how we understand this judgment of Tribok Maruti Kirkan. Mr. As we are wrong.
Yes, no, Your Lordship, no, Your Lordship. My only concern is with regard to this answer, Your Lordship, is that she being the only person, Your Lordship. Now, injury with regard to it, like, if he has,
I'll tell you a circumstance. I'll tell you a circumstance.
yes,
Now you see, there are about 30 to 40 learned advocates sitting in the room. Okay. Now, if you ask me for 2 or 3 familiar faces, I will not be able to name all the learned counsel who are present in the room. Now, what happens is suddenly somebody drops a file in the floor, and there's a loud sound, dum, that sound comes.
Mm.
It is at that point of time that I find the lawyer who actually dropped the file. Before that, he was unassuming. The lawyer was, we did not notice that lawyer. It was only when he dropped, then we noticed that a lawyer was there. Now you are arguing before this court. So if I ask you the question, look, you were arguing and therefore you made this file fall down. And I accuse you of what you call of the what you call this disturbing circumstances which has occurred in the courtroom. Now you are arguing with the court, you have not seen the dropping of that. So if I ask you this question, can you explain how that file was dropped? Now what would be your answer? I don't know why it had dropped.
yes.
Correct. So a circumstance must be shown adverse to the one making it. And then this question would come under 313 if you are reading this paragraph 16. Correct.
My only concern, Your Lordship, if I may be allowed, Your Lordship, a small submission, Your Lordship. Now, this person is found dead, Your Lordship. She shout for help, Your Lordship. She informs the villagers, Your Lordship.
She's not asking for help. She's only
Informing the
Mar gaya,
villagers
mar
that Margya Margya. Now, my only concern is that she being alone, if she does not even know, Your Lordship, if she have heard a sound, like one of the witnesses said, there might be some bulgari in the house, or her own statement, because IO statement 161, whatsoever is IO has taken, has always been asked in his cross-examination. And as per IO's statement, he says that she, on inquiry, has stated that he had fallen in the toilet floor, Your Lordship. Now, there has to be an explanation to that, which under 313, nor in her defense, because when she give her own defense, Your Lordship, she is against that, against the allegation made to her that she has murdered, Your Lordship. There is no explanation even in her evidence, Your Lordship. Now, she herself admits to the fact that no one came to visit the house, Your Lordship. Meaning thereby we are discarding any interference from the third person, Your Lordship. Now, this person is found dead on the bed. There also, Your Lordship, is also seen the photos, Your Lordship. There is a person on the bed dead without any of bloods would be a different, there might have been a stroke or something that analyzation could have been made, Your Lordship. However, this person's, his body was swollen, Your Lordship. He had blood on his face, Your Lordship. Even the wife did not inquire about the same thing, Your Lordship. Now, with regard to any other relationship, that would have been a different case, Your Lordship. There is a clear admission that there was a quarrel, Your Lordship. He was drunk, Your Lordship. Now, my only submission with regard to only that particular point that there was no explanation is that she was the first person in the house. She stated that we slept in different beds, Your Lordship. And during the time of death, she was at kitchen, Your Lordship. And that this is chased her away from the house, Your Lordship. Her statements are so contradictory that, Your Lordship, even her 313 and DW are totally contradictory, Your Lordship. Now she has been given an opportunity to defense against her own self for all the allegations, Your Lordship. Even in that defense, there is no explanation. Your Lordship will also, in her own defense, see that she had not heard any sound of hitting the deceased by lathi or etc., Your Lordship. So there any intruders, any assumption with regard to intruders is also nullified, Your Lordship.
Yes.
Yes, your lordship. Yes, your lordship. Yes. Yes. Yes, your lordship. Yes, sir. Yes, sir. Yes. 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 Yes, your lordship. Yes, your lordship. The death was, therefore, the death was internal bleeding, your lordship, and head injury, your lordship. Yes, your lordship. Swollen wrist. Yes. Sir. Yes. 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 And jaw, your lordship. Yes, your lordship. Yes. Yes, your lordship. Your lordship, page number 26, your lordship. 26, your lordship. 20. Yes. But the main reason of the injury was the internal bleeding, your lordship. Your lordship. Yes. Yes, yes, this forehead part, your lordship. Yes. Yes, your lordship. Your lordship, only with regard to the custody, your lordship has referred that wife and husband, your lordship. I'll just read, your lordship, though not convinced, I'll just read paragraph 17, your lordship. Yes. Yes, yes. Deeply obliged. Yes, paragraph 17, Your Lordship. The judgment that I have given. Second last paragraph, Your Lordship. Yes, Your Lordship. Lordship, if I may read, Your Lordship. Second last paragraph, Your Lordship. Second last page. Last paragraph. Lordship, in 313, Your Lordship, the question that was offered to her was explanation to her injury. Yes. 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 The only my explanation to the motive is yes. Yes. Your Lordship. Yes. 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 Yes, Lord. Yes, Lord. Yes, Lord. Yes. Yes, Lord. Lordship, I would just like to place just one judgment. This is Lordship XCC Online, 2024. Para 44. Just Lordship, I'm not going to read out. Just saying that 106 of Evidence Act cannot be invoked to make up the inability of the prosecution to produce evidence. Yes. The section cannot be used to support a conviction unless prosecution has discharged the onus by para 44, Lordship. Just that, Lordship. So my inability to explain or whatever, those are additional links and not just, it cannot be form the main part of the circumstances. Only if they are able to prove the first part, then only these things may come into play. Tijini, your lordship.
The private respondent.
Matter stands adjourned today to enable him to file affidavit in opposition in the matter. Next, brother. This is a writ petition of 2020, and therefore it is made clear that if affidavit in opposition is not filed within the time allowed, the court will proceed to hear the matter on the basis of materials available on record, and no further adjournment will be granted. List after 3 weeks.
Much obliged.
This is 5, 6 also.
6 also, lordship. 6 in petitioner, lordship. 6 petitioner, lordship.
6, Mr. Lawrence petitioner. This is in view of adjournment of WPC 349 of 2020. List this matter after 3 weeks. Only that one line. Nothing. Okay.
Much obliged.
Ma'am, lordship, I beg to mention item number 13. In this, we need some more time. We haven't received our instructions yet. Consent has been taken.
Again, you have informed the other side.
Yes,
My
ma'am.
lords, this is a petition under section 11 of the Arbitration and Conciliation Act for appointing an arbitrator on behalf of the respondent. Item 13, my lords.
Yes.
Yes, my lords. They had
After
informed
how
my,
much time?
After 3 weeks, ma'am.
3 weeks. But do it because these arbitration matters, unless you do it on time, you can't adjourn it on a drop of the hat. Okay, both sides are represented. One last opportunity is granted to Miss Mamu, your first name, government advocate. Matter stands adjourned today. So as to enable her to file affidavit in opposition in the matter. Next for a list after. Give a date after 3 weeks. 17 June. Okay.
I'm grateful, man.
My lord, I beg to mention, my lord, item number 10, 11, and 24, my lord.
Yes.
10, 11, 24, my lord, this matter may be taken after 3 weeks, but I yet to file the affidavit, my lord.
My lord, I'm for the
But
petitioner.
how much time will take?
My lord,
How much time will
my
take?
lord, 3 weeks, my lord.
Okay. What's the represented?
My lord, I'm appearing on behalf of the petitioner in item number, my lord, 11. But my friend, my lord, the matter may be listed after 2 weeks, my lord. It's because on the last occasion also they took time for
No,
filing.
making it last chance. If we don't
My lord.
give, we will proceed. List after. One last opportunity of 3 weeks is granted to the respondent authorities to file affidavit in opposition in the matter. So it is very clear that if no such affidavit is filed, the court will proceed to hear the matter on the basis of materials available on record.
My lord.
10, 11, and
10, 11, and 24, my lord.
24.
My lord.
Same order.
Declared, my lord.
In item number 24, interim is there, so in item number
I
20,
said all present. I have said all present.
no, yes, but interim is there, so interim may be continued.
Yes, item 24.
Declared.
Okay.
Development.
May I please, my lord? My lord, I beg to mention item number 3, my lord.
Yes.
My lord, leading counsel for the prisoner is feeling not well today, my lord. So matter might be taken up for next week, my lord.
It's represented. On the ground that the council holding the brief is unwell. All the matter stands adjourned today. List after a week.
My lord, item number 22 also.
Same. 22, same.
And my lord, 32 and 33 also. my lord.
13 and 33 is for respondent. No? 32, 33. You've taken consent of the other side?
Yes, my lord.
Okay. Say what?
Obliged.
My lord, RTA number 18, I would like to take adjourn for 4 weeks here.
Why?
Your Honor, my lord, it's
Just
Arup
say-
Bhattacharjee, petitioner,
show this item.
advocate,
Item 18.
18. And we have taken concern with other parties, my lord also.
Yes. Both sides are represented on the prayer made by counsel for the petition of the matter since adjourned today. Next, we take note of the fact that despite adjournment granted on various occasions, our affidavit in reply has not been filed. First of all, accordingly, it is provided that if affidavit in opposition is not filed within 10 days from today, the matter would be heard on the next date on the basis of materials available on record. First off, no adjournment will be granted at the instance of the petitioner on the next date, list after 3 weeks.
Lordship, I have filed one writ petition this morning. I have said it will be taken as a last item today. The urgency your
What is
Lordship,
the urgency?
Lordship?
What is the urgency?
Yes, your Lordship, I have been served with a vacation notice, and today is the last date of that order. So,
Okay.
thank you, Your Honor.
Please, Lord. Lordship, I beg to mention item number 9. I'm on behalf of Mr. G. Riva, leading counsel for the petitioner.
Both sides are represented on the prayer made by counsel for the.
Kindly fix this matter on 10th of June.
Since adjourned today, list on 10/6/2024.
Highly obliged.
My lordship. Lordship, I beg to mention on behalf of R. Saikya, item number 4, Lordship. Correspondent number 1, standing counsel for EPIC. Honor, his health is not good today, Lordship. The matter may be adjourned. I have taken the consent from the others.
Both of them represented on the prayer made by counsel for the respondent number 1. Matter stands adjourned today, list after
2 weeks, Lordship.
2 weeks.
And Lordship, item number 7, Lordship. Here for the Standing Council Highway, Lordship. Respondent number 2. I have taken
You
the
taken
consent.
consent.
Yes, Lordship, I have taken the consent.
All sides are represented on the prayer made by Standing Council Highway. Matter stands adjourned today, list after 2 weeks.
2 weeks, Lordship. And Lordship, item number 23, Lordship. Here, Lordship, service upon all the respondent has been completed, Lordship. I'm for the petitioner. Items 23, 2 and 3.
2, 3.
Yes, Lordship.
Service is complete.
Yes, Lordship.
The 23. Counsel for the petitioner submits that the case is ready as regards service. Must accordingly list the matter in the admission column.
Lordship.
And for the private respondent number 8.
All sides are represented. All sides are represented. See. Okay.
Obliged, Lordship.
Number 1.
May I, my lord?
Yes.
My lord. The petitions are for my lord Malini village, my lord. They are the landowners of land measuring 97,911.67 square meter. Now, what happened, my lord? Without the knowledge of the writ petitioners, this respondent authorities.
You will issue a notice. You issue a notice, right?
My lord, I am seeking interim, my lord. I'm praying for
What is the
it.
interim order?
Yes, my lord.
What is the interim prayer?
Not to disburse the compensation amount.
Not to? Well, you
Disburse
see,
the compensation.
once you are saying that there is no notification, question of disbursement will never come.
No, my lord, the compensation amount, my lord, that's why, my lord. Every process was initiated clandestinely without our knowledge. No publication was done. My lord, kindly see our representation, my lord.
No, no. You see, if you have that information that they are going to release, that means there will be some, somewhere it is in connection with some proceedings that has been, must have been noted. You have all the information except one information where the, which is the case where they are trying to give the compensation. How can that happen? How you have part knowledge?
No, my lord. My lord, on May 2023, I came to know about it. So why I
No,
submitted
that's
one
okay.
representation, my
No,
lord.
no, that's okay. But you see, you must be saying, you must be having some knowledge. Where is the statement made?
My
That
lord.
is-
May I, my lord?
This is the same case, my lord, on which, my lord, the last occasion, my lord, two read petition, read appeal. That is the connected matter, my lord. The wherein, my lord, the amount will be deposited by the Union of India with the Deputy Commissioner. This is the same case, my
Page
lord, wherein,
31,
my lord.
31, page 31.
Page 31.
Para 16, my lord. The
That's
petition,
okay. You come to know. Just tell
Yes.
us how your information can be part.
my
You
lord.
come to know about it. You don't know the case number where it has been initiated. How can that happen?
Being known about this pendency of writ appeal, my lord, we have filed an application before the Honorable Court, my lord. It is in page number, my lord, page 85, my lord. And order was passed by your lordship only, my lord. Page 114, my lord. We tried to be intervener in the writ appeal, my lord. But some suggestions was advanced by your lordship, my lord, because our course would be merged with, my lord. Yes, page 85, my lord. Starts from page 85, my lord. So we prayed for, my lord, for implement as petition, my lord, in the writ appeal number so and so 41. Now fearing that our cause will merge with the writ appeal filed by the Union of India, my lord.
What was the order passed?
My lord, that would be 114, my lord. we were given liberty to, my lord, file appropriate application, my lord. Appropriate, my lord, page 123, my lord. 6/12/2023, page 123, my lord. We sought liberty to file a fresh application, my lord, before this honorable court. Since no publication was made, my lord, the acquisition process itself is void, my lord. My lord, may I please come to page 64, my lord. This is our representation to the Deputy Commissioner, my lord. Specific, our allegation, my lord. Page 64, my lord.
This is an acquisition under which act?
2013, my lord.
2013. With the title.
2013, my lord.
Like to pair.
Section 11, my lord. Section 11 is pari materia to section 4 of Land Acquisition Act 1894, my lord. Section 11, my lord, we are claiming section.
Just now, here's something else.
Hey, 2013.
Yes, you can tell us the proceedings, what you call, the details of proceedings. You have it?
My lord.
Do you have the details of the proceedings? Do you have that?
My lord, proceedings of.
Of this land acquisition?
My lord, this is the case wherein, my lord, the even state government by way of affidavit, my lord, filed that no procedure was adopted, proper procedure adopted, and that this is void ab initio, my lord. That is the statement, my lord, filed by the same, my lord, officers in charge of that particular district, my lord, who, my lord, initiated the process for the land acquisition. That affidavit, my lord, it is somehow connected to the writ appeal which your lordship has heard on the last occasion, my lord. This is the time and again our contentions that no procedure was adopted, no procedure was followed by the, my lord, the district administration of their own, my lord, everything has been done, my lord.
What did we
Now
do?
even, my lord, my lord,
We reserved this judgment, right?
yes, my lord.
2 days back, we reserved this judgment.
My lord.
That same matter.
Same matter. Now, my lord, another proposition is if, my lord, this, my lord, again, this particular, my lord, in that, my lord, the respondent in that writ appeal, my lord, if they are allowed to receive the compensation amount, my lord, as per the, my lord, judgment of this honorable court, wherein, my lord, determinations for direction was given for the determination. Again, the same compensation will be given to the another person by the Union of India, my lord. Chances of the making payment double way will be, my lord, always there, my lord. It's because this same gentleman is filing one writ petition saying that I am the owner, and the another way, my lord, they are saying that no, this is a community land. Unless it is not determined, my lord, the procedure followed, my lord, established under the provisions is not followed, my lord. The chances of the making payment of the government, my lord, exchequer's money will be, my lord, the go waste, my lord, for same plot of land.
So therefore, my lord, it is fair to make submission, my lord, this needs, my lord, the proper adjudication. In the meantime, my lord, may interfere in the, my lord, the impugn, my lord, the proceedings and the notification as well, man.
I'm for Malini area only, my lord. I'm from Malini village. my lord.
Serious likelihood of, my lord, the misuse of the, my lord, the public money. We are ready to pay to the, my lord, or real owner once it is determined and the, my lord, as per the, my lord, the provisions. And whoever entitles, my lord, we are ready to pay, my lord. Our only contention is, my lord, that much
No,
amount,
that doesn't interest because of the fact that you see under the right of compensation,
my lord.
right of fair compensation, there this exercise must be prior to doing it. Because you see, we are also disturbed by the fact that whatever order is passed here will affect the writ appeal.
My lord,
Result the judgment.
to my knowledge, my lord, writ appeal is subject to whether the requisition, when the requisition has not been made by the, my lord, the Union of India, my lord, whether the acquisition is valid or not. That was the issue, my lord. My issue is that land acquisition was initiated without our knowledge, my lord. No publication, my lord, no two-paper publication, my lord, no local language in the Panchayat municipality B, C, and E, my lord, in the affected areas, my lord. We are claiming section 11 B, C, and E, my lord, which was not carried out, my lord. So why we were unaware of the, my lord, notification or publication. No, firstly, my lord. Again, my lord, the second thing is that, my lord, this so-called private respondent, my lord, he is from Italian village, my lord. He is not from Malini village, my lord. Now he claims that the land which is located in Malini village belongs to him, my lord. He is from Italian village, my lord. This is our specific claim, my lord. At least had we been known about the land acquisition process, my lord, we would have, my lord, made our objection.
What is the writ appeal number?
41, my lord.
Huh?
41
Of
22. My lord, I would like to place one judgment on it.
yes.
My lord, this will require some adjudication, my lord. My lord, I'll just show your lordship at page 48. This is the first writ petition filed by the private respondent. Ngasi Mena. Page 47 starts, my lord.
Yes.
Here on page 48, the fourth para, my lord. My lord will see, it is the case of the petitioner that the writ petitioner is the permanent resident of Malini village under Italian circle under Dibang Valley district, and their community land was taken by the ITBP from Assam Rifle in the year 2005. He states that it is their community land. Now, my lord will kindly come to page 52. Here, this is a communication by the Deputy Commissioner to the Secretary Land Management regarding notification of so-and-so. This is the list, if my lord will see, the list of beneficiaries at serial number 5. And parcel of land to be acquired is given below. Here, at serial number 1, Sri Ngasi Mena, the area acquired is 97,911 and location Manili. He becomes the sole owner. Now, therefore, how this was determined, that has to be looked into, my lord. Now, these are the writ petitioners who claim that it is their community land. And this private respondent, Ngasi Mena, also has stated in his earlier writ petition that it is their community land. Now he becomes the sole beneficiary.
Yes, my lord. My lord, may see the award, my lord. Page 57, award. The page 58, my lord, may see, my lord. Page 59, my lord. Sorry, my lord, page 59, my lord. Page 59, my lord. Page 59, serial number 1, my lord. Award has been first in the name of particular person only. This is Nasi Mena.
Now this writ petition
My lord, may I? My lord, I would like to place one.
See, the stand which you are taking, Mr. See, Mr. Kato, this, you are asserting what the petition is saying. that you also are not aware of the manner in which publications were made, correct? Now, let us assume that you are correct. Even you don't know what has happened. That means that the procedure of this right to fair compensation was not followed,
Correct, ma'am.
correct? Now, if once you say that, that means within the meaning of section 19 of the Right to Fair Act, right to fair compensation, the proceedings or the initial classification of the requirement of the land that would lapse, correct? Once that lapses, your entry into the land becomes illegal, because without the process of land acquisition, you could not have been in possession in the first place. Therefore, please tell us by when you are vacating the land.
My lord, the peculiarity is the land was already under the possessions of the
No, I
ITBP.
understand, but the government of India cannot say that I have usurped the land of the citizen. You are expected to be a model, what you call, for everything you are a role model, correct? So can you hold over a land without there being acquisition proceedings? If not, and if you support the petitioner that nothing was followed, then you vacate that land. You can't hold on the land and say that everything is not known illegal. So you can't be the beneficiary of your own illegality. Then,
My lord, that is, my lord, admittedly, my lord, the legal aspect, my lord. To secure the my lord, nation, my lord, earlier the Assam rifle was there, my lord. And no point of time when the land was under the position of the Assam rifle, my lord, they never raised any objection, my lord. When the ITBP, my lord, was inducted in the state of Arunachal Pradesh, the ITBP, my lord, the Assam rifle has been shifted out.
no, that
And-
means, can we take it from your submission that the government of India is an unscrupulous authority just because there is no objection?
Fairly
to take
not,
over
my
the
lord.
property of a citizen?
Fairly not, my lord. But however, my lord,
No, but
my
you
lord,
see,
that has to be regularized in such a way. Mechanisms, my lord, has to be worked out, my lord. So
The
that
mechanism is there, my lord. They have to pay the lease, my lord.
my lord, lease and the rent, my lord, any other things, my lord, that
lease
has to
cannot be
be.
presumed.
From the date of possession, my lord, it can be, my lord.
It cannot be presumed unless then action is taken under the Requisition Act,
My lord.
where you agree to pay liability.
My lord, state government has formulated, my lord, even lease amount, my lord.
One judgment, SL Jain, my lord. SL Jain or
Don't
SK
tell us
Jain.
because these things are basic preliminaries. You have Constitution of India with you.
No, my lord.
You borrow it from us.
My lord.
Read Article 299.
299. 299, my lord, contracts.
Yes, 299.
All contracts made in exercise of executive power of the union or of a state shall be expressed to be made by the president or by the governor of the state, as the case may be, and all such contracts and all assurances of property made in exercise of that power shall be executed on behalf of the president or the governor by such person in such manner as he may direct or authorize. Neither the
So number one, very elementary point. A lease is a transfer of property
Right.
under the Transfer of Property Act. And any dispute? 111 of the Transfer of Property Act. It's a lease. Sorry, it's not 100, it's 106, I think. Let's see, Transfer of Property Act. 106 to, maybe one or two, since I'm growing old,
No.
maybe one or two provision here and there. I may be plus minus somewhere. 106 Transfer of Property Act, correct?
Right.
Now that is, lease is a transfer of property. Property is a disposition which can only be done if it is Union of India with the consent of the president, because in the name of the president, you can only enter into the contract.
Right.
You cannot say that the lease is without any agreement. But that is no lease at all. A presumption of lease can't be there. It can only be by the executive fiat of the state, where they create a contract by way of acquisition proceedings.
My lord,
And then requisition proceeding, and then they say, we undertake to pay rent
my lord.
to you. So therefore, you see, it's all these declarations are done in the name of either the governor, because for requisitioning, you will have to issue a gazette notification.
My lord, my lord. My lord, may please come to section 80 of the LARR Act. LARR Act 2013, section 80, my lord.
Okay.
There is a mechanism. This issue was before the Honorable Apex Court, my lord.
Give that act.
I have the act, my lord. Section 80, my lord. Interest, my lord.
Oh, lease is 105. I was referring to 106.
My
It is 105 of the transfer of property. So I am wrong by one section.
Well, this issue was, my lord, was before the Apex Court, my lord, regarding possession of land before acquisition, my lord. So the petitioners therein has filed a writ petition, my lord, which went to Supreme Court, my lord, on the interpretation of section 80, my lord. May I read section 80, my lord? When the amount of such
18 of?
compensation is not paid,
18 of?
80, my lord, of 2013 Act, my lord. LAR Act,
2000.
yes. Section 80, my lord, 80, yes, my lord. Payment of interest, my lord.
Oh, that will never come. Once it is your stand that there was no notification,
My lord,
question of delayed payment of interest will never come.
my lord.
Because
The
you see,
position, it will be position.
no, those arguments are very difficult to accept.
My lord.
You have seen the Limitation Act? This Limitation Act. Doesn't take you anywhere.
My lord, my humble prayer is, my lord, that the entire acquisition process is void, my lord, for non-compliance of mandatory provision, my lord. May I read one judgment, my lord? I would like to place one judgment.
One by one,
Right.
don't overlap two things.
Right.
You gave me one proposition, I am showing you something.
My lord.
You don't jump over another. Yes.
My lord. May, my lord.
Now you see, for that proposition you argued,
My lord.
this Article 65 of the Schedule of the Limitation Act has 12 years of limitation. They are claiming that the land was acquired sometime in 1950 or 59, I forgot. Since Assam Rifles days.
Right.
Since then, you never claimed your ownership and title. And therefore, once the principles of adverse possession that comes into foreplay,
Right.
now tell us, how would you acquire a right to have a notification in your favor for the
Right.
purpose of land acquisition when the claim itself, based on previous title, becomes time barred?
My lord, I've gone through one judgment in the live law which says state cannot perfect its title by way of continuous possession.
Where do you find
Well,
it?
net is not working here. My lord.
I don't know this. And what is this, that second judgment?
This judgment, my lord, well, non-compliance of mandatory provision, my lord. 2012 6 SSC, my lord, 348.
Now that-
2012 6 SSC 348, my lord. Para 11 to 14, my lord. I would like to read, my lord. May I read, my lord? Yes, my lord.
You won't succeed then.
My lord.
You won't succeed then. Because it is your case that they have not initiated any acquisition proceedings.
Yes, my lord. This one, the entire process is void, my lord, now.
No, no. Process never initiated cannot be void.
May I read this judgment, my lord?
No, no. Does it say that even if no process is made, the process is void? It
Yes,
can't
my
be.
lord. Yes, my lord. It says, my lord.
So
May I read?
pass it on, pass it on.
Para 12 to 14. 11 is also section 11 of 2013 Act, my lord, and section 4, my lord. They are perimeteria, my lord. So from para 11 would be important, my lord.
Correct. Look at this. Paragraph 4. Essentially, there has to be some catch. There can't be a judgment in a void.
Para 4, my lord.
I'll tell you the story of this case. You hear it from me. For the purpose of military, the government acquired land in Maharashtra near Bombay for the military purpose. And then in this notification, which is there at paragraph 4,
Yes, ma'am.
you will find that the notification under section 4 and 6 were issued.
Yes.
And it was only in the name of a Nadiawala. Now, therefore, the persons who claim to be the interest holder in that land, they approach the government to allow them to inspect the records as to whether notices were served on them, because they are the persons interested.
All right.
Here also in the Land Acquisition Act, in the earlier act, section 11, here there's some different section saying that a person interested is having a right to a notice.
All right.
Therefore, they went to the government that please let me inspect the records as to whether notice was served. Because in the writ petition that stand was taken,
Right.
notice was served. Thereafter, what happened was that if it was not granted, therefore under 226 to 27, they approached the High Court.
Yes, my lord.
And then they found out that the notice was not served. Therefore, they are now saying that the procedure was not followed and therefore it is quashed.
Yes, my
That's
lord.
right. Now,
That is my
see-
case also.
You see, for that, what is required is there was a section 4 and 6 notification.
Right.
Preliminary notification and the section 4 notifications were there,
My lord.
correct?
My lord.
That was said to be without following any procedure. It does not say when then when the land itself is not acquired, then the process is bad.
My lord.
It can't be, because if there is no process, the process can't be bad.
My
It
lord.
can be an illegal possession,
My lord.
but a process cannot be bad.
We can say, my lord, they are in illegal possession, my lord.
No,
But
that
this
is not your
acquisition
case.
process, my lord.
That is not your pleaded case.
Because this is my pleaded case, my lord. My lord, this
Your
acquisition
is not
process, my lord,
maintainable.
this my lord, land acquisition process, my lord, this award has been passed, my lord. This award, my prayer is that, my lord, to quash and set aside the entire land acquisition process, my lord, and even the award and preliminary notification, my lord. My lord, may I please come to my prayer, my lord. Thirty-four, my lord. Yes, sir.
Yes.
My lord, may I read, my lord? The writ of certiorari shall not be issued quashing and setting aside impugn notification dated 24 for issued by the
Where is
sorry,
24
page 34, my lord.
No, page 24 for that notification is where? Which page?
Preliminary notification, my lord.
24
Yes.
where is that? Which page?
It is in page 54, my lord. No, sorry, my lord. In page 52. Yes, 54, my lord. Everything was done internally, my lord.
Just a moment.
Yes.
One by one. Yes.
Page 54. Again, my writ of
54.
certiorari shall not be issued setting aside impugn gazette notification dated 10/5/2018, my lord. Page 55, my lord.
55.
Yes, my lord.
55 is not 10-5.
This is, my lord, no, on the top, my lord, gazette notification, my lord. 10 May 2018, my lord. Here in the middle, my lord. Published by authority, my lord. Roman 15 Nahalagan, Thursday, May 10, 2018, my lord.
Okay.
Yes, my lord. Writ of certiorari shall not be issued quashing and setting aside the impugn award dated 6/9/2018, my lord.
Where is that?
Now that is in page 57, my lord. 57. This is the award, my lord. Page 57 to 59 is the award, my lord. And my lord, I am also praying, my lord, the writ of certiorari shall not be issued quashing and setting aside impugn notice dated 22/1/2019 issued by the deputy commissioner, my lord. That is page 60, my lord.
60.
60, yes, my lord. By this notice, my lord, they have taken the possession of the land. The deputy commissioner, my lord. May I read, my lord? The second paragraph, my lord. Therefore, on expiry of stipulated 30 days post publication of this notice, all the land mentioned in the schedule below will be taken into possession by the government of Arunachal Pradesh for establishment of ITVP BOPs in Dibang Valley district, my lord. Now, my lord, my fifth prayer, my lord. The writ of certiorari shall not be issued quashing and setting aside entire land acquisition process carried out in respect of Malini area of Dibang Valley district, my lord. And I am also seeking mandamus, my lord. Prayer 6, my lord. The writ of mandamus shall not be issued directing the respondent authorities to initiate process fresh land acquisition process in respect of Malini area of Dibang Valley district, my lord, under the provision of so and so on.
Okay, then we are issuing a notice then.
My lord, entry may be granted, my lord. Because, my lord, if there is no entry, my lord, the beneficiary would be this private person, my lord, who claims to be the owner of 97,000, my lord, 97,911 square meter, my lord. How can, my lord, this person, we have specifically made our allegation that, well, this person is from Italian village, my lord, and we are from Malini area, Malini village, my lord. Now, Malini area which belongs to Malini village, my lord. I am from Malini village. We are 49 in numbers, writ petitioner. I am from Malini village. The area comes in Malini area. This private person, my lord, this private respondent, who is from Italian village, my lord, he claims the land in the Malini area belongs to him, my lord. And the land acquisition process was initiated in his name, my lord, without any notice to us, my lord.
You are arguing against Article 16, no discrimination by way of place of residence. What is that?
No, my lord, it's not like that, but at least a person who is a resident of a particular place, His land holdings also is in Malad.
Mr. Vijay, you may be a rich person, you may not go to a place, but you may still have a property in Bombay.
My lord, this 97,000 square meters, my lord. 97,000.
Why not?
This, my lord,
If you have
in fact,
money-
my lord, in the writ petition itself, my lord, this, in the first round of litigation filed by the private respondent, he himself claimed that this is a community land, my lord.
Where is that?
My lord, in the judgment, my lord, page 47, it starts from page 47.
7.
Paragraph 4, my lord.
Page 47, para
48, my lord, 48, page 48. Yes.
Para 4.
Para 4, my lord. It is the case of the petitioner that the writ petitioner is the permanent resident of Malini village under Italian circle under the Devang Valley district, and their community land has been taken by the ITV. When he claims that this is a community land, how can it be a private land, my lord?
Okay. Okay, now I made a case. That is the petitioner and counsel for the petitioners. Also heard. Mr. City Conduct standards for the Land Management Department and bringing for respondent number 1, 2. And Mr. N. Radan, the additional division appearing for respondent number 3. And Mr.
Under that for respondent number 4,
Okay,
5
because
and 6 months.
We are appearing for respondent numbers 4 to 6.
Well,
Next paragraph. By referring to the order dated 14/3/2017 passed by this court in WPC 78 AP of 2017, filed by respondent number 7. An observation is made that the said respondent number 7 was referring to the acquired land to be a community land. First of all. However, it stated that in the award
Page 59, my lord. 57, 57, my lord. 57, my
that
lord.
in the award passed on the 6/9/2018 for a total sum of rupees not required, award passed, the land of Alini, ALINEY, no, not Alini, Malini, MALINEY, was shown to be in schedules 2 thereof, Roman 2 thereof, is shown to be the land of respondent number 7 with a total compensation of rupees 54,80
5 crore,
no,
my lord.
5,48,30,534 assessed in respect of the said land. Full stop. It is further projected that the respondent number 7 is not an ordinary resident of Malini village,
Malini village.
Malini village. But he is a resident, permanent resident of Italian, Italin, Italian village. And therefore, it is projected that the respondent number 7 cannot have a community right over the plot of land referred to in schedule. It is referred to in the award. Dated 6/9/2018. Next, the case of the petitioners is that the entire acquisition proceedings was initiated behind the back of the petitioners, and they were not served with any notice of the intention of the respondent authorities to acquire their land. Accordingly, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the notification dated 24/4/2018, issued under Section 11 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act, 2013, within bracket 2013 Act for short, bracket closed, Gazette notification published on 10/5/2018 in respect of the same notification, and the award dated 6/9/2018. As well as the notice of position dated 22/1/2019.
19. 19. 19.
Next paragraph. In support of the contention of the petitioners, Mr. M. Katolan at CGC, as her DSGI, submits that the stand of the Union of India is also that the proper procedure for land acquisition was not followed in this case. First of all, he also submits that initially the land was provided to the Assam Rifles in the year 1959.
Yes.
And that the ITBP is now in possession of the said land through the Assam Rifles. And it is submitted that the stand of the Union of India is that the proper procedure was not followed in the entire acquisition process. First off, he also submits that the Union of India has also put up a challenge to the acquisition proceedings, which is now part of writ appeal number 41 of 2022. Let's go. Next, we have the, which is reserved. Where judgment is reserved by the division bench. Where judgment is reserved in the division bench. Let's go. Issue notice returnable in. Give a date after 5 weeks. Returnable on so and so. The Petitioners shall take steps within 2 days for service of notice on the response number 7 by registered post with AD. Full stop. Formal steps will not be taken on the respondent numbers 1 to 6. Stop, however. Requisite extra copies of the writ petition will be served on the paying council within 2 days. Next one. On the in view of the submissions made by the learned counsel for the petitioners, which finds support from the learned DSGI, the what is it trying to direct the deputy commissioner dash land acquisition authority from Anini district.
Anini is a headquarter, my lord. Anini is the headquarter one. Dibang Valley district.
Huh?
Anini is the headquarter, my lord. Anini,
Okay, what is it, the name of the district?
Dibang Valley district, yes.
Okay, well, Diwan Valley district. Anini, not to disperse any land acquisition compensation. To the respondent number 7, namely Sri Nagasi NAGSI, MENA of in respect of Malini MALI village quantified in Schedule 2, Roman 2 of the order dated 6/9/2018 and the memo number capital this page 57 memo number is mentioned also, amounting to rupees 5,48,30,534. Then further orders of the court.
Right. Highly obliged.
I'll take a break and come back.
Wait, please, Lordship. My lord, for the purpose of construction of road up to Changlagam by the BRO, the lane were to be acquired. My lord, accordingly, my lord, the duly constituted board has submitted their report. May I just take Lordship to an extra 3, my lord, straight away, my lord, page 18, my lord. My lord, I have 2 issues in this letter.
I think we issue notice here.
My lord.
We issue a notice here. But I find it very strange.
My lord,
Sir, Ratan,
my lord, one more, the second aspect is slightly, it's pertinent to highlight the Lordship. My lord, may I just take Lordship to page 37. 37, this is the final cumulative amount. My lord, here the first aspect, Lordship, that up to 10 kilometer, that aspect is there, my lord. The second part is, my lord, in this case, your Lordship will find that only the amount and contingency charge has been included. But, my lord, as per law, the calculation pattern has not been followed. There is no provisions or the provisions of Lara Act 2013, like inclusion of solitium, then multiplying
they'll
factor.
respond to it. They'll respond to it. Because here, Mr. Ratan, I find it very strange. All these details of estimates and everything are given, but nobody keeps a track of photographs. Although everybody has a mobile. Now, nobody keeps a track. And this estimate of horticulture, I have repeated it many times in this court. You see, last time when I was here, I had gone to the market. I tried to have cardamoms grown in this state. I couldn't find any. Because among the crops, you get cardamom crops, then you get 2 or 3 more things. In the local market, they don't have any. So therefore, if you have so much of horticultural growth here, why we don't find that in markets? It's not that every citizen of this state eat only dry fruits or fruits.
Unfortunately, my lord, neither the agriculture nor the horticulture department, they have this mechanism for marketing. Now only the trade and commerce department has just recently, they have taken up.
I have visited many places. I can understand in Itanagar you are not there. But tell me about the village you are there. Today if you go, I take a holiday tomorrow. Let me go to this place and let us find the local market there. I'm prepared to take a holiday tomorrow. Can we go and find it? We'll take additional advocate general also. We'll compel him to go rather. Can we find in any place? You can contact your client. Tell us in any place.
In
where the-
Anjao, you will find it.
Huh?
In Anjao, you will definitely find.
Anjao in the market, no. The prices are very high.
And then Malat in this Yazali area.
Huh?
So yeah, just on the way to Zero,
Huh?
that Yazali actually area.
No. In that market area, you don't find anything local. Last year I visited there. And in fact, when you reach that market, before reaching Zero, you have a market on the right side, a very big market. And local items are not there. This cardamoms and this horticultural items, you don't find it there.
Actually, my lord,
Even in the kiwi season, this kiwi was what you call very high price in the peak kiwi season during winters.
Kiwi will be available from the November,
winters
October,
actually.
November.
In Zero, it was not available. I don't know.
actually, my lord, this is regarding cardamom, my lord. Earlier, it used to yield very good benefits to the farmers. But since the rate has gone down in the market, they have stopped this cultivating this cardamom. Now they
Are you aware of the market rate of cardamom?
Instead of cardamom, they are
Are you aware of
cultivating
the
this rock now.
Are you aware of the cardamom rate in the market?
Yes, earlier, no, sir, I'm not
No, because in my jacket,
aware of that, but then
in my jacket, which I can't wear it in the courtroom, in my pocket you will find cardamoms. I keep it.
Another aspect is, Malot, there is no value added system because this cardamom it's quite big and then very strong, and this has to be processed with certain kind of value added addition. So that procedure also is not there.
I don't know. I'm only when I did this compensation claim, then I find that if that is the amount of compensation claim, anybody can have it. Incidentally, you are telling me about the cardamom processing. I'll show you something. In my free time, I only do this. Price of cardamom dryer is 4,70,000 in the market. Correct. So when you are asking for compensation of 35 crore, 4,70,000 or something, though this money would be peanuts. See, it's just not possible to accept that a farmer would be growing horticulture worth crores of rupees and would not know the.
I think, Malot, Mr. Ratan should know this, that right? Presently, only the Trade and Commerce Department,
I don't know,
they
I'm
have
not-
started some process. Otherwise,
Patil,
there
I'm
is no
not-
mechanism
no,
at all.
Mr. Patil, with all humility at my command, I'm not questioning you. But what I'm saying is that there's a serious doubt created when I find these things. And this is just my part of my hobby. You-
It is not very difficult to process it.
It's not very difficult to process. So when you're asking for a claim of crores of rupees, 470 is peanuts. Okay, issue, have Mr. T. Patil done it. Counsel for the petitioners. Mr. K. Ramdu Planet, Gossip for respond number 1. Mr. N. Ratan Dhanan, petitioner advocate general appearing for respond number
2 and 3.
2 and 3. And Mr. M. Katwala, DSG appearing for respond number 4. You should notice returnable on same date, give after 5 weeks. Returnable so as as all the respondents are represented. Issuance of formal notice is dispensed with. Mr. However, requisite extra copies of the petition be served on them within 2 days. Next one. The pendency of this petition shall not be a bar for the respondent authorities, for the respondent number 2 to complete the process of assessment of left out properties. Next, list on Spencer.
May Lordship. May Lordship. Lordship, here, Lordships, the private respondents, Lordship, here themselves implemented as a respondent, Lordship. And Lordship, governments filed their affidavit, and I also filed my rejoinder, Lordship.
It will go for hearing.
Yeah, Lordship.
When do you want to be heard?
Lordship, today, Lordship, at least next day may be given, Lordship, for hearing, Lordship. If
No, when? Tell us when do you want to be
after
heard?
2 weeks, Lordship, and Lordship, it's here, Lordship, government, Lordship, private respondent number 2, Lordship, the settlement officer, Lordship, deputy commissioner, Lordship, required to file affidavit, Lordship.
Why?
Lordship, here is the land availability certificate is given by the deputy commissioner, Lordship, as a land settlement officer, Lordship.
No, deputy commissioners file an affidavit.
Not yet, Lordship. Here filed by respondent number 1, principal secretary. 3,
Just one.
3 forest officer.
Just one.
Here, Lordship, this respondents, Lordship, again, allegations made against allegedly allegation to the that this is the respondent to allegations made to the respondent number 2, Lordship, deputy commissioner from
No,
for
no,
reasons
in
for the
fact-
issuance
no,
of.
no. In fact, in your case, the land was declared to be a reserve forest.
Yes, Lordship.
So it is only the forest department who will take a call.
Yes,
The
Lordship.
other authorities would not have any right to say anything.
Yes, Lordship.
Respondent 2 has filed an affidavit, no.
Not filed, Lordship.
Forest. Who is appearing for the forest settlement officer, forest officer? I think Lordship
Government, Lordship.
Lordship, forest is filed, Lordship. Has filed.
Forest is filed, Lordship.
Then nobody else is required. Your LPC will have no value.
Yes. Then, Lordship,
If it is reserve forest area, then your LPC will have no value.
Lordship, here is no, in case, my Lordship, without the consent of the whole area, Lordship, 500 hectares of land, Lordships, is donated by the private respondent, Lordship. Without the consent of the This land is not the land of the private respondent lordships. Without the consent of the blazer lordship, this notification land is donated lordship and reserve and work is carried out lordship. So lordship, we pray for the
Who has done that?
lordship,
Which people have donated this land?
private respondent lordship who implemented themselves as a private respondent number 5 to 9 lordship. Donation pays his lordship in petition annexure lordship, 3 lordship, deed of donations.
But then your reputation would not be maintainable.
Lordship, here lordship, this is maintainable lordship.
But it will not be maintainable because you see, now it is your case that these 4 people have donated their land.
Yes, lordship.
Correct. The donation has not been cannot be challenged in a writ petition.
Yes, sir.
If you want to challenge a donation, you
I'm
have to
not
file a
challenging
civil suit.
donation lordship. Donation we not challenge lordship.
Then
Lordship, we came to know donation lordship, we challenge the notification lordship. Notifications as our land is full.
you can't challenge that. How can you make a collateral challenge without affecting the donation?
Donation lordship. Here lordship, donations is in the backdoor lordship. The government lordship.
Whether it is right or wrong,
Lordship.
somebody has donated it. Now the donation itself is not a challenge. How can you challenge the notification, subsequent notification of based on that donation of land? The reputation will not be maintainable.
And then lordship, that may be lordship forced for hearing lordship.
We already heard it.
Admission
There's
hearing
nothing more to be
lordship.
had.
Sorry.
There's nothing more to be had.
Lordship, at least lordship, my senior will be appear lordship, this case lordship.
Okay. When do you want?
After 2 weeks lordship.
Okay. It's really- what do you call it? It's a notification of reserve forest, right?
Yes, lordship. For denotification lordship, we
Both sides are represented. It is noted that the petitioners have received the notification regarding declaring 500 hectares of land to be of Radpur, RADHPU, Village Forest Reserve. The court finds that after the land is declared to be reserve forest, or the affidavit of respondent number 1, 3, and 4. Would suffice. Full stop. Whatever private respondents, they are not appearing.
lordship,
Private respondents,
no lordship, yet not filed lordship.
also right. None appears on call for the newly inflated private respondent numbers
5 to 9 lordship.
5 to 9. Then next, accordingly, list for here. Let's just see. You have the issue raised in this requisition, the requisition stands admitted for hearing by issuing rule returnable forthwith without requiring any fresh steps to be taken. Next, this is the matter for hearing after 2 weeks.
Okay, much obliged.
Yes, you've got instructions.
Lordship, will be filing affidavit. But I'm told that this proposed exam has been is will be cancelled by second week of next month.
My lord,
So the matter may be listed after 2 weeks, Lordship.
When is the exams due?
Lordship, there,
13-1. That is already gone.
Lordship.
The
Exam is gone, Lordship. Exam is gone. And then we seek time from the Honorable Court as well as the parties also that some modification is required in recruitment rules. There, now that will be taken up in next week, Lordship, next week, Lordship.
Both sides are represented. Mr. P. Arpan, the senior counsel, assisted by Mr.
K. Miller.
Counsel. Submits that the authorities are expected to take a decision within a week. And accordingly, he prays for 2 weeks' time. Appraise the court of the subsequent events. What if any? Matter stands adjourned today, rest after 2 weeks.
Of life.
Match of blood.
Item 14.
My lordship,
Yes,
we have received our instruction in filing, my lord.
we'll be filing. By when?
Within 2 weeks, my lord.
Huh?
Within 2 weeks.
Okay.
Lordship, this last judgment, even last occasion also they are taking time because it is admitted fake, Lordship. It was only the non-payment of payment bill, just 90% has been already paid, only 10% is remaining, Lordship.
They can file, they are asking only 2 weeks' time.
Yes.
Both sides are represented. Mr. P. Vangunaran, Government Counsel. Prays for further 2 weeks' time for the affidavit in opposition in the matter. Next. As the petitioner claims unpaid bill to the extent of rupees 1,09, 62,437. The respondent authorities have ensured that the affidavit in opposition is filed within the time allowed. Next, at least after 2 weeks.
Last chance will give. Like.
Item number 15.
Yes. Yes. What is
May I,
it?
Your Lordship? Your Lordship, I'm appearing on behalf of learned standing counsel Peter for Union Housing. Your Lordship, I'm yet to file counter affidavit, Your Lordship. 2 weeks time may be granted, Your Lordship.
But will you file it within the time?
Pardon, Your Lordship?
We'll give you time, but will you file it?
Yes, Your Lordship. Actually, the office affidavit is ready, Your Lordship. We have called that official to appear for swearing, but they did not turn up today.
All for the petitioner. on the clear made by learned counsel for the respondents. List after 2 weeks, so as to enable the respondent numbers 1, 2, and 3 to file affidavit in opposition in the matter.
Item number 16.
Yes.
Yeah, Lordship. Lordship, I'm appearing on behalf of J. Genie, Your Lordship.
Yes, you filed your affidavit.
Yes, my lord. We have already filed, my lord. Respondent number 1629, my lord.
Of course, we'll be relying on the. Yes.
Yes, Your Honor. If respondent number 3 and 4, they are relying on the affidavit filed by the union. So matter may be fixed for admission hearing, Your Lordship, on next date.
Okay. All sides are represented. The learned standing counsel for the respondent number 4 submits that they would be relying on the affidavit in opposition filed by respondent numbers 1 and 6 to 9.
Respondent number 5.
5.
Yes.
Where is that? Where is that? From here. Oh, yes, it is there. It is there. The respondent number 5. So accordingly, there's a matter in the admission column after 2 weeks.
My lord, I'm extremely sorry, my lord. At number 15, my lord, there was interim order, my lord. Yes, interim order, my lord. At number 15, my lord, there was interim order, my lord. That may be 15, my lord, 1 5.
Just tell the still.
Yeah.
Okay. Yes.
Item number 17.
My lord, here, respondent authorities has filed their affidavit.
Yes.
Private respondent is yet to file affidavit, my lord. Respondent number 4, my lord. In respect of respondent number 5, my lord, private respondent number 5, the address of the respondent number 5 will not be found out because he might be transferred to some other place. So therefore, I will be able to take this step through Director of Education. In respect of private respondent number 5, my lord.
state respondents have filed their affidavit of opposition. I have filed rejoinder also.
No, but five,
My lord,
you cannot serve respond number five to the Director Secondary Education. He has no business to find out people and serve notice.
My lord, when the petition was filed, you was transferred at that point of time at the secondary.
No, we can request the School Education Department shall ascertain the correct postal address of respondent number five and inform it to the learned counsel for the petitioner.
Present place of posting.
Present postal address or place of posting. The same shall be done within 2 weeks. To stop on the address being. Okay, so further orders will be passed thereafter, just after 2 weeks.
After 3 weeks, my lord.
3 weeks. Okay, 3 weeks.
Obliged.
Item number 19.
Yes.
Yes, my lord. Yes, my lord. Yes, my lord, respondent number 2, 3 and my lord 4 is still in, my lord, is still yet to file in affidavit in opposition. 3 and 4, my lord, private respondent 4.
It's okay, they have not filed.
The affidavit filed by respondent number 1 will cover.
That's okay, whoever is not filed is not filed. You're for who is filed for respondent number 1? So you can cover for 2 and 3 also. Correct.
1 and 2.
So vice for 2 and 3 also. 2 and 3 are same. Under the same department.
Same department.
ICDS social welfare.
Respondent number 1 is the secretary.
No, that's okay, but these 2 are subordinates. 2 and 3, they can cover for 2 and 3 also. You're saying only 2.
2, Lordship. But Lordship, since there was some communication there.
No, if that will suffice for number 2, why not for number 3? That is my question.
Oh, Lordship. Lordship, we have communicated, but there was no court coming. Therefore, the affidavit filed by respondent 1 will forward.
For 2 and 3 also.
Lordship, for 3.
And 2?
2, Lordship, we have filed.
You filed. Where is that? When did you file it? When did you file it? Oh, yes, it's there. Okay. The petitioner and respondent numbers 1, 2, and 3 are represented. Now there is a call for respondent number 4. The Mr. I, the government advocate submits that the affidavit in opposition of respondent number 1 shall also cover the stand of the respondent number 3. Stop. Next, as the case is ready in the service, list in the admission column after 2 weeks.
Lordship, kindly pass about this matter for time being. Council is in other call.
Pending.
Yes, ma'am.
My lord. My lord. Item 22, my lord, service report is awaited, my lord. Item, we have taken step and, sorry. So, my lord, may I pray that, we may be allowed to serve through DAS team.
On which respondent?
Respondent from 1 to 4, man.
1 to 4.
Yes, madam. Deputy Commissioner, Secretary Land Department, and then Commandant BRT, Chief Engineer BRT.
And all of this are served.
Yes, madam.
All of this are served.
No, not yet, sir, madam.
So no, there are.
We have taken step, and as per the record, it shows that service report is awaited.
How many respondents are there?
4 respondents.
Three respondents.
3. Oh, sorry, 3 respondents, my lord. Yes, 3 respondents. Sorry.
You're sure number 3 is still there?
Yes, my lord.
Respondent number 3 is still there.
Respondent number 3, my lord. Because the order was passed in the.
It will not be here. Okay, on the prayer made by Mr. S. more than cost for the petitioner. The petitioners are permitted to serve notice on the respondents by way of Dusty. But after processing the steps to the registry of the court, steps within 2 days, the returnable date of the notice is give a date after 5 weeks. 1 July 1/7/2024. Upon service, an affidavit of service shall be filed prior to the next date of listing. Let's put this from 1/7/2024.
Right.
Yes.
May 21. My lord, this is an interlocutory application bar. Praying for my lord the re-verifying and re-verification of the exit area at New Anyaya Village Community, then illegally occupied by the MS Dibang Multipurpose Project under National Hydro Power Corporation Limited, without making any compensation to the affected family, my lord.
No, but this prayer in the interrogative application cannot be allowed. Because it would amount to allowing of your prayer number 1 in the writ petition. It will give you final relief. You see prayer number 1 in the writ petition.
Yes.
Same prayer you are making in the interrogative application, that can't be done.
Manas, here actually this application is filed for allowing the
I don't
petitioner.
know, you prayer number 1, look
Yeah.
at your prayer number 1, it is for re-verification. So if I allow this interrogative application, your final prayer would be allowed. You can't do that.
Manas, petitioner will bear the all expenditures.
No, you see, that's not the issue. The re-verification process
Yes, ma'am.
is your main prayer. If I allow an interrogatory stage, then the prayer number 1 will become infructuous.
Hmm.
By way of a interim relief, I can't allow main relief.
Malo, in writ petition also, Malo, same prayer was made, Malo.
Then we'll have to postpone this inquiry till the.
So, my lord, if this petition is allowed, my lord, into the application, my lord, then automatically that writ petition will be, my lord, infructuous, yes.
So we can't allow your interim prayer. Interim prayer can't be allowed. That is your final relief. We can't allow in the interrogative stage.
My lord, this was filed on the basis of, my lord, the deputy commissioner's recommendation, my lord. My lord, currently is annexure B, page 17, my lord.
No, I'm not disputing what you are saying, Mr. Som.
Yes.
The problem is that your prayer number 1 is the same. So we have to keep it pending. Can't allow your application.
My lord, if in the event of, my lord, allowing this application, my lord, then automatically, my lord, writ petition will be, my lord, suspended.
That's why we can't allow that.
Hmm.
This can be a final relief, but it can't be interrogatory relief. Once you make that prayer. We'll put this for hearing early. You have filed your affidavit in the main writ petition. You can hear that matter.
And in this, there are other respondents mentioned.
What are the other respondents?
Land Management, Ministry of Hydropower Corporation.
Has it been served?
Right, let's proceed.
This is from your writ petition. It has another defect.
My lord.
You have named respondent 5 without employer being there. We can't issue a writ on the managing director or the executive director. Any mandamus issue has to be on the National Hydro Power Corporation.
Yes, my lord, we have sought the
See, number 5 is executive director.
executive director,
It's a defect of formal nature. The hydropower is not even a party here. How can we bind the executive director?
Respondent 4 is Secretary, Government of India, Renewable Energy.
Secretary can't be, you see, Union of India can be represented by secretary, but secretary does not, it's not a Union of India. It's a formal defect. It's a formal defect. Employer is not a party. Hydro Power Corporation is not a party. How can we issue a writ on the executive director? Will not be bound by the writ. He will say, my employer has asked me to do X, I am doing X.
Manu, in that even, let me correct
You have
it.
to amend it. You
Amend.
have to amend it, otherwise it will be, it will be a formal defect. But Mr. T. Songdal, counsel for the applicant, and Mr. is T. one more. K, I'm sorry, I made a mistake earlier also. Right, K one. K one more, and government advocate, appearing for respondent number 3. Yes. And you are from?
I'm on behalf of Senior Advocate P.K. Tiwari, Your Lordship.
So you are here. And Mr. D. Kamdal,
For NHPC.
for respondent number 1 and 2. CGC, anybody is here? No. The book finds that the made in this interlocutory application is same as the prayer number 1 made in the connected writ petition. So therefore, if the interlocutory prayer is, if the prayer made in the interlocutory application is allowed, it would amount to grant final relief to the petitioner in respect of prayer number 1. So accordingly, the consideration of this interlocutory application has deferred. Next, sorry, in the repetition, this matter stands adjourned, sine die. To be taken up along with the connected writ petition. In the writ petition, you say, Mr. T. Song for the same. Next one. It appears to the court. Say your name, I forgot. Your name?
E. Payang, on behalf of E.
Payang, on behalf of respondent number 5. Presence with your partner. On a perusal of the first title of this writ petition, the court finds that there is a formal defect in arraying of respondent numbers 4 and 5. To stop. The secretary who's made the respondent of 4 may represent the government of India, but
Union of India, man.
Therefore, the similarly, in respect of respondent number 5, it's seen that the employer of the respondent number 5 is not a party to the writ petition. Next, for accordingly, the learned counsel for the petitioner is granted liberty to amend the cost title in respect of respondent numbers 4 and 5. Next, for accordingly, the learned counsel for the petitioner shall submit a amended cost title to be incorporated in the writ petition. So the same may be regarding the amended cost title, she is to the concerned section in charge. We will strike out the present cost title. Seven A. Striking of page number 7, instead of the new cost title is 7A. So, amended cost shall also be provided to the appearing, the appearing counsel for the respondents. Full stop. Yes, what is your stand in the repetition? What do you want to say?
Your Lordship, I was only instructed to inform the Honorable Court that we will be filing our Wakalatnama in a day or two. We have not yet received.
The counsel appearing for respondent number 5 submits that he would be filing a very possible sorry, the department most of this week. So accordingly, they should also file their affidavit in opposition within.
Your Lordship, in the meantime, we will file our affidavit.
But it's also done as affidavit in opposition. Next. List after how much time?
After 2 weeks.
List. Okay, we file
Alright.
affidavit list after 2 weeks.
Instead of executive director, it should be managing director, I think.
Ask someone, it should be the employer first. Managing director can't, he is not bound. It will be the corporation will be bound. But the corporation, if it takes a decision, the managing director will say, what can I do? I am a service holder. They've asked me to do this, I am doing that. The corporation will be bound. Next item.
Sorry, cyanide means automatically it's vanishes.
Sanitize it, John, we can't help it. I'm not dismissing it. I'm not dismissing it, but I'm not dismissing it. Yes.
That here, as per the direction of this honorable court, we have taken the step. I'm for the petitioner. We have
Pardon
taken
me?
steps. As per the direction of this honorable court, we have taken the steps upon the respondent number 2 to 4. However, as per the office note, the service report upon respondent is still awaited, madam.
But the counsel for the petitioner, in view of the office note dated 22/2/2024 and 24/5/2024. Almost 3 months has elapsed. The petitioner is directed to take first steps for service of notice on the respondent numbers 2, 3, and 4 by registered post with AD. Except within 2 days. First of the learned counsel for the petitioner is granted liberty to collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. Next, the notice is made returnable on after 5 weeks. 1st July 2024. List on 1/7/2024.
If I may pray, there is an interim order, interim status quo.
Interim order passed earlier stands extended to the next date of listing. Okay. This time you submit the postal track report.
Obliged.
I'm sorry, madam, I was in the number 2.
Malat, this is the communication, Malat, pertains to your lordships of we, Malat, convey to the Malat, the ministry, and ministry has Malat, filed, Malat, prepare everything, Malat, not the duly authorized, only to be filed today. But due to Malat, the cancellation of the flight, due to the cyclone, Malat, yesterday, so officer could not able to come for Malat filing. Malat, everything is done, only for filing purpose, Malat, only.
Could we give them a week?
Malat.
Okay, thank you.
And the sense of the Malat ministry is very clear, Malat.
It's okay. The work is done. After that, I don't,
Yes,
I
Malat.
don't take personal interest after that.
Malat.
Once this has happened, that's okay.
Yes, Malat.
I'll just ask my counsel for the petitioner. And it's best happening on the senior advocate. Next paragraph. Mr. M. Katon and DSGI has produced a copy of instructions dated 27/5/2024 and submits that that due to cancellation of the flight due to cyclone, the affidavit could not be filed today. So accordingly, praise firm is granted a week's time to do the needful. Let's give a date after 10 days. Five, six.
My lord, maybe up to 7.
Produce take back your.
Pleasure.
Lordship, Lordship, here, Lordship, Lordship, here, respondent number 234, represented by Nitapa Lordship, IOC, Standing Council, Lordship.
Yes, nobody is appearing.
Previous occasions, he is appeared, Lordship. And service copies, extra copies served to them, Lordship, served to him, Lordship.
Okay. But the council for the petitioner and Mr. As well as the DSGI.
I am for the performer respondent only. Other respondent are the main respondents, my lord. I am performer respondent. Everything has been done by the other respondent.
Is notice served?
Yes, Lordship, notice served, Lordship, notice served, Lordship. Tapak, Lordship. IOC, Standing Council, Lordship. IOC.
Oh. None appears on call for respondent numbers 2, 3, and 4. This for forensic justice, the matter is adjourned today. Please stop in 2 weeks. Interim order passed earliest and extended till the next day.
Yes, interim may be continued. Interim may be.
Extended it.
Much obliged.
Item number 29 to 31.
Yes.
May I please, Lordship?
Just one, this is going to take some time. There was a prayer for new repetition, supplementary list. It has come. Just one.
Yes,
have a
yes,
supplementary
no,
list.
no.
Taken. Supplementary list.
Item number 94.
We'll take this as a option matter, then we'll take it up.
Lord, by
Yes.
filing.
Well, by filing this writ petition, I have challenged the very formal process.
Just a minute. Mr. Prakash, so this is something we can't examine. We have to dismiss your writ petition.
Exactly, my lord.
Charge sheet we are not examining.
No, yes, my lord, Lordship, very much, my lord. It can be challenged, it is amenable to jurisdiction. I can cite the decision, my lord. Because, my lord, the charge, if doesn't constitute any, my lord, misconduct, in terms of Supreme Court decision, A.L. Kalra. Lordship will examine this question, I am not praying for any interim order. Because suspension.
Shows that Karla decision. Show that Karla decision.
Yes, Kalra decision shows, my lord, if the charge is under general head, by taking the aid of general head, you cannot, my lord, initiate a department proceeding. Therefore, it is not a misconduct. If it is not a misconduct, then what is the question, my lord?
This is the judgment. First.
My lord, now, 1984, 3 SCC, 316.
1984.
My lord, 3 SCC, 316. In a, my lord,
313.
316.
6.
Yes. In a similar situation, my lord, one, my lord, department proceeding was challenged and stay was granted. That was in respect of, my lord, director of Rajiv Gandhi University, Arunachal Pradesh. Therefore, Lordship will examine this question. Lordship may formulate a question, and I may be given the opportunity to address the court. On 6th, Lordship may fix the matter.
No.
Otherwise, my lord, it will require some time to apprise your lordship.
First, let me be satisfied.
7. Writ petition is pending. Only allegation is that, my lord, I facilitated the department to.
Which paragraph?
Paragraph. My lord. Page 17. Rule 4. It starts from Rule 4, bears the heading general. Page 17.
Which paragraph of the judgment?
My lord, page 17, it starts from Rule 4, bears the heading.
No, I won't have that page unless you show me.
My lord,
I won't find it out.
And suspension order, my lord, same allegation I have made, suspension order notice was issued and matter is pending. Same allegation, my lord, on the basis of same contention. Can you see the charge? Whether it can be, my lord, constitute to be a misconduct. Somebody has filed the affidavit, my lord, I was a nodal officer, directed to deal with all the files. And on the, my lord, on the top, my lord, government admitted 2 affidavits were filed by the government, admitting the claim of the petition. Subsequently, my lord, there is a turn, a new commissioner came, and he took a, my lord, decision that government cannot admit the claim. That case is pending, my lord, for final hearing. 7th year, adverse, my lord, respected advocate general appeared. I being a nodal officer, I was directed to deal with the file. I was directed to examine the matters. I was directed to, my lord, keep a touch with the advocate general office. And all on a sudden charge was brought. The affidavit was filed at my instance. And without the approval of the government, affidavit was filed. Can it be the basis to start a criminal proceeding?
Mr. Pulkayastha, look at this judgment, this A.L. Karla.
Yes.
In one of the paragraphs, you will find
Yes.
that not only the disciplinary committee
Yes.
passed an order, but the appellate authority also upheld the dismissal. So when the challenge was made and when it reached the Supreme Court, it was the decision of the disciplinary authority and the appellate authority which was being examined, and therefore at that stage the Supreme Court interfered. This A.L. Kalra is not an authority on the point that even a charge sheet can be quashed by the.
No, this is not the question, my lord. What I trying to apprise the lordship. Initially stage, my lord, there must have some misconduct. And prima facie, if the charge sheet doesn't show that is a misconduct, then it is an abuse of power. So why should I not raise this question before the court to invoke the judicial review?
No, you are showing A.L. Karla. Karla is not an authority on that point.
Karla says, my lord, you cannot take the advantage of general head, may not initiate a development process unless the charge is covered by particular head. And I have checked up the CCS conduct rule. This is under general head. Only my lord should examine this question.
No, we have examined. That's why I'm asking you a question.
My lord.
When I'm asking you a question, that means we have seen that.
And my lord,
Because one of the ground you have taken in this writ petition is that the charge was made against you. Arbitrary excess of power and there's malafide. That is a disputed question of fact. What is malafide?
My lord.
It can't be examined by that.
No, malafide ground, my lord, I can raise this question. I can raise this question, my lord. Since my lord 14 matter is pending, they are trying to, my lord, claim the relief for area salary in terms of recommendation of 5th and 6th CPC. And my lord was, my lord, ultimately, my lord, in 2018, last affidavit, present writ petition was filed. Government filed 2 affidavits saying that yes, in view of the decision of the government, since approval was granted, therefore we are not going to dispute the claim. 2 affidavits were filed. And charge sheet, my lord, reflects that. My lord, charge sheet dated, my lord, affidavit dated 18/10/2022. That affidavit was filed by the department. My director and my lord, nodal officer, both are placed under suspension. Once you admitted the claim, file affidavit, now you're saying it is falsely or my lord, by way of my lord, misrepresentation it was filed. Can you see the language? An affidavit was filed without the knowledge and approval of the competent authority. Who am I to take the, my lord, approval of the government, my lord? I'm simply a nodal officer. I'm just to keep in touch with the, my lord, all government officials. And my lord, the order by which I was appointed as the nodal officer, there is some specification regarding the assignment of duties. Nowhere it is said that, my lord, before communicating or before, my lord, placing the record before the appropriate authority or advocate general or government of officials, the official of the government advocate, I shall have to obtain prior approval of the government. And my lord, in a similar situation, my lord, Manglichan Behra, he was the director of Rajiv Gandhi University. In a similar situation, he was, my lord, placed under suspension. Ultimately, was initiated. I have challenged that. Ultimately, court entertained. And if necessary, I can place on record the relevant order of the court. And he is Manglichan Behra, Professor Manglichan Behra. Court interfered, put personal order. Interim order was granted.
Yes, what do you say?
My lord, this is my lord, charge has been my lord, memorandum has, the charge of memorandum has been issued. Now, if he is not involved, and he is given adequate opportunity, he has to defend matter. It's not the case that he has not been given opportunity. But in case of such matter, matter, only limited scope is whether he has been afforded opportunity or not, whether the allegation is whether there's a substance or not, there's the substance or not. That is to be proved, my lord. He can very well he can participate in the proceeding and disprove the allegation, my lord. The scope is very limited, man. Only to that aspect, whether he has been afforded the opportunity of hearing or not, man. In case of such nature of the case. Even, man, the recently, man, the paragraph, recently Supreme Court, man, paragraph 36, 39, man, it's categorically held, man. Regarding such nature, my lord.
Can you give me the reference?
I'll just read the para 36. It is now well settled that the scope of judicial review against departmental inquiry proceedings is very limited. It is not in the nature of an appeal, and a review on a merit of the decision is not permissible, my lord. It is not the nature. The scope of inquiry is to examine whether decision making process is legitimate and to ensure that findings are not read and any evidence.
That is regarding after decision.
Malab, this is what, Malab, when even here in this case, a proceeding, Malab, has been issued a memorandum of charges.
You have raised a very rightly pointed out the question, whether it is within the, my lord, competence of the read court to interfere with the charge sheet. So, Lordship may have formulated the question rightly. Give me some opportunity, I will address the court, madam.
No. You address whatever you want to address it. Because I have a question.
No, because this question was there regarding maintainability rate petition. So, I need some time, madam, to satisfy your lordship. It don't happen. Nobody will be prejudiced, madam. If some time be given to me.
Mr. A.K. Purgasar, counsel for the petitioner. Mr. T. Kagum, standing counsel for all the respondents.
Malab, respondent 1, 3, 4.
Respondent 1, 3, and 4 raises the issue of maintainability of the writ petition on the ground that sufficiency of charges cannot be examined by a writ court, and it's only and therefore the scope of judicial review against the submission of charge sheet ought not to be examined. First, on the preliminary issue of maintainability being raised, the learned counsel for the petitioner takes some time to address the court. Accordingly, matters stands adjourned today. List on
7th. 7th of June.
7/6/2024.
Yes.
Deeply up.
You take that. Yes.
Item number 35.
Yes, may I submit?
Yes, where is the order? Huh? No. Yes, where is the order impugned in this?
Page 50, Your Lordship.
Huh?
Page 50.
15.
50, yes. 50. 50.
50.
Yes.
Yes, Mr. Dhiran.
Yes, Your Lordship.
This notice is under which provision? 134. What does 134 CRPC say?
It's Your Lordship, service of or notification of order, Your Lordship.
Then
Your Lordship, I'm raising the very maintainability of this writ, Your Lordship.
why?
Because this order has been issued under CRPC, Your Lordship. Then
No,
he has
that's why we are
ample-
asking you. You see, 227 does not say only against civil. 227
Yes, Your Lordship.
it doesn't say that it is only available against orders passed in civil exercise of civil jurisdiction. It is superseding jurisdiction of the court. Correct.
Yes, Your Lordship.
Now, this one part. Second part is that this vacation notice is under 134. Under 134, where is the provision for this?
Your Lordship, that is wrong, Your Lordship. It seems, Your Lordship. But Your Lordship, he has a remedy under the CRPC.
Protection Act. They are not covered by it.
But Your Lordship, in in our court only in WPC 3057 of 2020, Your Lordship, it has been observed that in case of Rahendra Baglari versus
Yes.
Subdivisional Judicial Magistrate.
It's a reported case.
Uh,
No,
that, Your Lordship, it is in live law, Your Lordship.
just pass your tab. Give the J, Judicial Officers Protection Act. It's in J. Right. Absolutely right.
Yes.
He's subdivisional judicial magistrate. They are what you call they are protected under the Judicial Service Judicial Officers Protection Act. Section 6 protects them. Executive magistrates are not excluded. I'll show you that. Because he's an executive magistrate. Just I'll tell you why. Just yes. This is that Judicial Officers Protection Act. People in 1850, there's something wrong.
The network connectivity is very problematic today, Your Lordship.
Not opening.
Yes, Your Lordship.
I'll show you. This is high industrial dispute, J. Yes. This is, you find it more comfortable. This is the same thing.
Yes.
This is the same thing, correct? Now, I'll show the difference. No, not required. Here, you have a CRPC, give it to CRPC.
No, yes,
You have a CRPC, huh? See section 11. Section 11 is Court of Judicial Magistrates.
Court of Judicial Magistrate, Your Lordship.
Correct.
Yes.
Now, in every district, not being a metropolitan area, there should be established as many courts of judicial magistrates. Correct.
Yes, Your Lordship.
Now, come over to section 20.
Pardon, Your Lordship.
Correct. So there's a distinction. These are executive magistrates. Now, in executive magistrates, you'll find you'll see you have seen this section. You marked those words very correctly. You see, it is not the district magistrate which is included. It is the collector included. You know why? Because revenue side, the collector decides on revenue sides, and revenue court is a civil court.
Yes, Your Lordship.
Correct.
Yes, Your Lordship.
Now, revenue court is a civil court, and therefore collector is there. You see the words. It doesn't say magistrate. Executive magistrate doesn't say.
Yes, only
It does
magistrate.
not
Your Lordship.
say district magistrate. So by excluding district magistrate, they say collector. The collector is a revenue court.
But Your Lordship, if we see the language of
And the judgment you showed us,
yes, Your Lordship.
correct, this judgment which you showed.
Yes, Your Lordship.
Here you will find that it's an SDJM. SDJM is again a judicial magistrate. So there's a difference between judicial magistrate and a magistrate executive magistrate.
But Your Lordship, if Your Lordship may use the provision of 138, Your Lordship, CRPC.
138.
138, Your Lordship.
138.
Yes, Your Lordship. If I may, Your Lordship.
Yes.
If the person against whom an order under section 133 is made appears and show cause against the order, the magistrate shall take evidence in the manner as an account.
No, that may okay. You see, any commission of inquiry, you will find section, there is a provision where it says that they will take an inquiry, and for that purpose, he will be a civil court or a criminal court. Doesn't make it, they make him a magistrate.
But Your Lordship, if we see the definition in section 2, Your Lordship.
Yes, you see it.
I, Your Lordship. 2I, judicial proceeding, includes any proceeding in the course of which evidence is or may be legally taken on oath, Your Lordship.
So arbitrator is also arbitrator.
Yes, Your Lordship.
He also takes evidence, but it's not excluded. Correct. It's not. It can't be.
It was my humble understanding. Your Lordship.
Inquiry, you see, inquiry is different. Inquiry for every purpose. Even section 133 of
Yes.
section 2, the roads and all, they will take an inquiry. 144, they can take an inquiry.
Yes, Your Lordship.
Fact finding they can do.
Yes, Your Lordship.
But doesn't make them a magistrate. They are just executive magistrates. So therefore, in the hierarchy of section 11, you will find
Yes, Your
it
Lordship.
will be the district magistrate. So you see, you must presume that when there is a legislature, no word is used unnecessarily by a legislature. So when they are including collector and omitting the district magistrate, there must be some reason.
Might be, Your Lordship, but this was my understanding.
No, I understand,
Yes,
but this is something I have dealt with it. That's why we are I'm so confident of making a statement. Otherwise, I would not have shown you this provisions of 1850 and this magistrates section 20. The reason is an inquiry under 133
Yes, Your Lordship.
is prerequisite for 134. Therefore, but here it gives them a notice. It can't be notice, it's a proclamation. Now,
No, Your
the
Lordship.
manner of service.
Yes, there is.
That is 134.
Yes, Your Lordship.
But 133 is a substantive provision. He does not use the 133. If he uses 133, then we could have relegated him to go to the Sessions Court.
Yes, Your Lordship.
So 133 orders are amenable under revision.
Yes, Your Lordship.
But 134 is an order which is not divisible. If you can show us that this can be done, 133 and 134.
Then Your Lordship, the question regarding maintainability may be open on the next day, Your Lordship.
Because it's a mode of service. Mode of service, there can't be an appeal or revision. It is the 133 substantive order,
Yes,
or conditional order, that is amenable to revision jurisdiction. That is the anxiety. Say the learned government advocate has raised the issue of maintainability of this repetition by submitting that the respondent number 2 is the district magistrate, and therefore the respondent number 2 is immune from challenge to his orders in view of section 1 of the judicial officers within bracket protection bracket was Act 1850. First off, in support of his submissions, the London government advocate has placed reliance on the case of just past that judgment. Case of so and so.
Unprovided.
Decided by so and so. No, by this court in so and so. Next one. The issue of maintainability is taken up first. Next paragraph. It would be appropriate to quote the provision of section 1 of the judicial officers within bracket protection bracket was Act 1850. Next paragraph. From the above quoted provision of law, it is seen that the said provision specifically includes the officers acting judicially first. The first of all, in this regard, we may refer that that in the criminal procedure code, the provisions of section 11 refers to the Court of Judicial Magistrates, whereas the provision of executive magistrates contained in section 20 of the CRPC. Full stop. In the present case in hand, the petitioner has assailed the order dated 22/5/2024, passed by the London District Magistrate Pasighat. Full stop. The respondent number 2 is the said authority, being the District Magistrate, East Siang District, Pasighat. Full stop. The petitioner has not arrayed the person holding the office of District Magistrate who has passed the impugn order. Full stop. Therefore, the provision of the provision of section 1 of the judicial officers within bracket protection bracket close Act, 1850 would not come in the way of the petitioner arraying the district magistrate as respondent number 2, because the order of the said authority is under challenge. Next paragraph. in the case cited by the learned government advocate, comma, the concerned subdivisional judicial magistrate was arrayed as a party respondent. Full stop. Therefore, the said judicial officer gets the protection under the said said judicial officers within bracket protection 1850. Accordingly, on facts, the case cited by the learned government advocate is distinguishable. Next one. Insofar as the next one, not so on the nature of challenge made in the present petition, issue notice returnable on how much time?
3 weeks, Your Lordship.
Returnable in 3 weeks. First of all, the current counsel for the petitioner shall serve extra copies of the writ petition on the government advocate within 2 days. Next paragraph. On the ground that the section 134 CRPC merely relates to the manner of service of notification or order, comma, the order of removal of nuisance could not have been passed under section 134 CRPC. The privacy clears, the privacy removal could not have been passed, which is otherwise contained. Which is otherwise contained in section 133 CRPC. According to the court, using time to stay the operation of the impugn order, page 50, number so and so, dated 22/5/2024, issued by the district magistrate, ECM district Pasigar, till the next date of district.
Obligation.
Hearing matter, I think we'll have to adjourn that. We'll not have time. Could be adjourned. And have it.
Yeah, as in the, yeah, I think last Friday, last Thursday, my lord has rightly pointed out that my lord, this case has been pending for so long, my lord, since the records have been called for. Therefore, my lord, like one small order can, if my lord permits, my lord, if the records can be sent, then the scan copy can be kept here, my lord. If the hearing is not taken, original records may be sent back. We were not aware that original records were here.
Well, the instead of that matter, if matter is disposed of, that is nothing survive matter. Instead of that matter, if matter is disposed of, the only thing is
we have to hear you, no? So make it Thursday. The positive time matter could not, all sides are represented. The positive time matter could not be taken up today. Missed on Thursday.
My lord, can it be on 31st, my lord? 31st.
31st will be last day. We will be,
my lord,
what do you call, we'll have to close all the matters, pass orders, make it online. That is the difficulty.
my lord, I have a little difficulty, my lord. My daughter's birthday, my lord. So he's out of station, so I need to go out of station.
Okay, 21.
Hmm.
Next week then?
Yeah, next week, my lord.
This
Next week.
after week is this week. Date to be fixed by the office.
Monday. Next week. Anytime. Christmas. 3. Seven, 6 is applicable.
Next week. In fact, what we're trying to do is, this is the, where is the LCR? Where is the LCR? In fact, what I think is that this trial court record
My lord.
would not be required for any purpose. The only question is about that deposit of the direction to deposit. That is the order under challenge.
Yes, my lord.
That can otherwise also be, because otherwise the entire trial is stopped. You just examine 457 one order, right?
Yes, my lord.
Yes.
In both the cases, my lord, that impugn order has been challenged.
Hmm?
In both the cases, my lord, that impugn order has been challenged.
You do a thing. We record your oral prayer and we permit you to file an interlocutory application for return of the LCR. Because you see what has happened from 2016, this matter is kept pending here.
Yes, my lord.
So instead of doing it by the order of the court, did the prosecution file application for return of the LCR on that ground? So
Ma'am.
we are giving you an oral permission.
Yes.
Next panel. At this stage, the learned you are appearing as a special prosecutor.
Yes, my lord.
Uh, Just write the names, Mr. K. Nolan
Yes.
for the petitioner. And Mr. O. Padal and then special
Public
public
prosecutor.
prosecutor for
SIC.
SIC. And Mr. M. Carroll, and you are for
Respondent number 2.
counsel for respondent number 2.
Your Lordship, in item number 30.
Pardon me,
In item number 30, Your Lordship.
you are there.
Yes, Your Lordship. In, as a petitioner, Your Lordship. State law.
There you are there for 2.
In item number 30, Your Lordship, the state government is the petitioner, Your Lordship. In item number 30, Your Lordship.
No, I'll record this. This is in first item I'm writing.
Yes.
Oh, sorry.
The second order I'll pass. This will be in first item, huh? Next, the learned special public prosecutor submits that the order of Zimma passed under section 457 within bracket 1 CRPC is under challenge in this criminal petition. And as the LCR has been called, the trial the trial has been suspended. So accordingly, it submits that there is some urgency in the matter, and therefore we praise that the records be sent back. Next, have you noted that this the original records were called for by a judicial order of this court, it would be appropriate that the state respondents file an interlocutory application for the court to consider this set prayer. Accordingly, no order is passed on the oral prayer made by the learned special public prosecutor. This is the matter. Due to positive time, matter could not be taken up today, as it is already 5 p.m. Hence, list on when
10th,
in
the meantime, I will file my application.
10/1/2024. And in the second case, in the second matter,
Same, Your Lordship, same order.
same order.
Yes, Your Lordship.
You are for
State, your petitioner, Your Lordship.
the petitioner.
Yes, Your Lordship.
Okay, so write it down for the petitioner. And same. Rest is same.
Yes.
The third one is item number 31. Under item number 31. Here I am for the petitioner, my lord.
Yes, I am cut off for the petitioner. Okay. So you are not there in the first case.
I'm there, my lord. In both the cases, my lord, I'm there.
In the other cases, you are there.
It's a private response.
But all of them are challenging the same impute order, my lord. So,
It's okay.
yes, my lord.
Because now we can, since it's a judicial order, I'm not modifying because in criminal proceedings, normally review can't be normally made, so therefore we are asking you to file it.
My lord.
Just file a small application.
My lord.
Don't need more details there.